কোনটা এইটা না? scheduled to be listed on the 23rd of September. Along with that, there are two other listed motions which are pending in lordship between the same party on the same issue. My lord, the urgency is that, my lord, the Memari municipality has announced by miking all over the place that they will be encroaching on the petitioner's courtyard to set up a health center. Earlier, they wanted to build a pump house over there, for which we filed a writ. Thereafter, they shifted it to another place. They did not build the pump house inside his courtyard. Thereafter, when he was going to give the boundary wall, my lord, the Memari municipality, with force and with threatening, stopped him. All his things are getting rotten. After we obtained an order in a police inaction matter, they kept on miking that very soon, just after the puja, we will set up a health center in his courtyard. So for which we have to file another writ. But if these three writs can be
Not at all. On apprehension, we are not going to allow a writ petition.
My
Do you
lord,
have a notice?
my lord,
Do you have a notice?
no notice.
Not apprehension. Verbal
notice.
apprehension.
My lord, but the officially announcing the chairman and the.
Show me one letter where they have officially announced.
My lord,
Show me one letter.
but it was miking in the locality that they will be entering into the petitioner's land and.
Verbal.
May I be permitted to mention an extension application, Your Lordship? It's
My lord, let them
No,
comment
sorry.
that we have no.
Oh,
we are
sir,
not
sorry.
contemplating.
Sorry.
Lordship, may I be
On
permitted?
the pensionary benefit, my lord, the same municipality, yesterday, your lordship,
Give us the-
yesterday, your lordship delivered judgment. They covered by the same municipality, covered by so
That's all right, sir. Doesn't mean
My lord,
Under urgent circumstances, this is a mentioned before your lordship, my lord. Otherwise,
give you a slip.
my lord, what happened, my lord? I pray before your lordship a leave to move one unlisted motion after recess because of the fact, my lord, Kolkata Municipal Corporation, by giving notice under section 401 on 29th August of 2025 upon my client for, my lord, construction a kacha shed in front of his shop room. My lord, they carried out, my lord, sudden demolition yesterday with the threat that shop room will be bulldozed tomorrow, my lord. Since today Vishwakarma Puja, they say that tomorrow day after tomorrow we are coming, my lord. My lord, only, my lord, shed, my lord, a tin shed in front of the shop room, my lord. No illegal construction. It is a
Even a tin shed is an illegal construction.
my lord, it is just to protect rainwater, my lord.
Even a tin shed is an
My
illegal
lord, without
construction.
any notice, my lord, without 400 order, my lord, without demolition.
All right, let it
My lord,
come in due.
my lord, may I come at, my lord, may I come at my after recess, my lord?
No, sir.
may I be
Otherwise, my shop room will be, my lord,
Go to the
my shop room will be damaged, my lord. My lord, kindly,
Nothing.
it will take, my lord, 2 minutes, my lord.
Nothing, sir. Nothing.
my lord, item
Yes.
Permitted to mention, my lord, on matter for application urgencies, my lord. On my land, my lord, I have no connection, my lord. Another construction is going on, my lord, by the local.
My lord, may I be permitted to mention monthly list item number 1812, Lordship,
Give
I
your
am,
slip. Give your slip.
Lordship, this is for non-prosecution. I have written instruction from the petition.
May I permit to mention, my lord, one illegal construction is going on, my lord, by the private restaurant without sanction plan, my lord.
Give your slip.
Very urgent, my lord. Very urgent. Civil.
From monthly from item number 1095, your lordship. He is a senior citizen, your lordship. He is facing heart issues, cardiac attack, your lordship. His pension was due from last.
Give your slip, madam.
Lordship for non-prosecution item number 252.
Lordship, may I be permitted, my lord?
Yes.
My lord, day before yesterday, I made an attempt, my lord, to mention this matter. My lord, what happened on Thursday, my lord, this matter was taken up. This is, my lord, the corporation, my lord, attachment of rain. My lord, we have already deposited more than 3 crores. And what happened, my lord, they are, my lord, taking rent from our, my lord, the respective tenants. And this particular amount is required to be incurred for the benevolent activities. It's a charitable trust. My lord, they cannot put, my lord, the padlock, my lord, threatened us to put padlock and thereafter, my lord, attach rent without observing the formality. Lordship was, my learned friend was asked for a, my lord, the Pashwa. Lordship was kind enough to place this matter after vacation. The only difficulty, my lord, the trust is running, led by 2 advocates of this honorable court. And, my lord, they are not getting salary. The employees are not getting salary. Well, KMC has taken each and everything of my earning.
So all these cases you should go before the tribunal.
No, not
All
tribunal,
these
my
are-
lord. This is a rent attachment, is not tribunal, before the tribunal.
No, you must have challenged the.
No,
This is a
the
subsequent
valuation,
action
the
which has
different
been
question, attachment of rent, my lord, they are required to perform certain, my lord, the obligation in terms of the statute. That
taken.
is why,
Give
my
your
lord,
slip, sir. Give
under to be mentioned or any.
Give your slip.
May I be permitted to mention a matter? Here, KMC had issued an order for demolition and unsanctioned G+5 was going on. The demolition order was passed 6 September 2025, yet no demolition action has been taken place yet.
Give your slip.
My lord, maybe from your lordship, the urgency is that I unauthorized, without any permission of me, the respondent number 4 is constructing on my private property. I am the owner of the
Yes, sir.
private property.
My lord, may
So what is this? This is, wait a
For
minute,
leave, my lord,
leave.
for leave.
What is the issue?
The issue is that I am the owner of the property. Without taking any permission or anything, the respondent number 4, the councillor is making a construction on my private property.
Who's making a
The
construction?
councillor of the ward number 21.
Do you have a title deed?
Yes.
Show me picture where he's making construction on your property. Nobody can make construction on your property. Show me the title deed.
Yes, I'm sure. That is the alley in the entrance of my property.
Is this your property?
It is my property.
The alley is a
No, no,
common passage.
It is not the common passage. The whole, I am
Nothing.
the owner of the whole property.
Don't say he's making construction on your property. These are alleys.
May I have my lord's kind leave to mention item number?
Don't make wrong submissions. Yes,
No, 150 of my lord's this.
give your slip.
May I have my lord's
Yes,
kindly, my lord, to mention, my lord, a matter which is item number 2959 of the monthly list. This is in connection with, my lord, a hospital called Ohio Hospital operating, my lord, from Newtown, where, my lord, at the time of renewal of the trade license, the NKDA authority, which is the municipal authority of the region, served a retrospective demand on the hospital, my lord, for a period which they are not permitted to under the law.
so why don't you go to the tribunal?
They don't have a tribunal under the NKDA Act, my lord. So I had to come up and file the writ. In the meantime, my lord, we had mentioned on the ground of urgency saying that unless, my lord, there is an order, my lord, permitting us, my lord, to apply and get the trade licenses, our other licenses will be blocked. My lord was of the view that no written notice to that effect has come. And therefore, my lord, we should mention later when the real notice comes. Now, my lord, on 8th of September 2025, we have received a notice from the Bidhannagar Excise District where they are saying that without the trade license of the NKDA, they are not going to renew our MD3 license for medicine.
All right.
Lord, kindly, Lord, let this appear, Lord, any day, Lord. This is, I filed a can in connection with this. This is the latest letter that we have come. Before placing our MD3 license, they want a copy of the trade license. And the NKD will not issue the trade license unless I give them the purported demand. I don't have a tribunal, my lord, before me, my lord. This can I have filed, my lord, immediately after getting this. The writ is, my lord, there. Let both appear, my lord, any day.
This original side,
If the appellate side.
Appellate side.
Friday,
Right. Obliged.
May I have my lord's kind?
Friday. Friday सुबह लगवाओ ना. हाँ.
May I have my lord's kind?
Give your slip.
My lord, may I be
Yes.
permitted to mention one pension matter for upgradation, my lord?
Give your slip, madam.
And may I have your lordship's kindly to mention item number 2529 of the combined list for upgradation. Urgency is this, my lord. On the common passage, my lord, the private respondent has constructed a high pedestal. For that's why, my lord, I cannot take my car into my garage. That is creating obstruction.
Give your slip.
I'm
My lord, may I leave to mention, the original side matter, disposed by matter, correction, my lord, one figure correction.
What is the correction?
Correction, respond number 3 to 5, instead of 5, that will be respond number 4, my lord. His order is there, my lord.
To be mentioned tomorrow.
Upgradation from your lordship's monthly. Upgradation.
Give your slip. Call out the matters.
for the corporation, bro.
Miller, I am for the state.
Yes.
Well, I am
I
for
am
the
furnishing, Miller, the report in the form of an affidavit as your lordship, Miller, direction.
well, we have
For the private party,
Yes.
No, I'm for the state.
state.
Respondent number 4, urban development.
And my lord, this is my exception to the report, my lord.
I've just received the same, my lord, in the.
My lord, yesterday I have sent through, my lord.
I'm sorry, my lord, I have not been able to follow the same, my lord. Kindly
I
date be
copied
fixed
in
up
the-
for hearing of it.
Report prima facie says, my lord, the land belongs to the state.
Well, I have
And it was
taken, my
duly
lord,
acquired.
well, I have taken, my lord, 3 points before your lordship, my lord. If your lordship kindly takes my report, if you, I can also say oral.
Can hear it out?
My lord,
We can hear it out, the matter.
my lord, any date, my lord, because exception I have just received inside the courtroom a few minutes ago.
No, no, well, I have already served him through WhatsApp, my lord. If my learned friend wants time, well, I don't object to that, my lord. My lord,
Yes.
but this is a case, my lord, wherein, my lord, the report has come, my lord, with greatest of respect, my lord, no documents has been furnished first. But this is the third round of litigation wherein we came before this honorable court, and my lord, the same question was taken out, my lord, whether this land was acquired or not. The land acquisition department, specifically this before this honorable court, relied that there is no acquisition proceeding. Nothing. Mala, I have entirely written in my notes along with the documents if your lordship wants. Mala.
They are saying in their affidavit that they have acquired
Ki bolche? Yes, Mala.
it. In their affidavit, they are saying they have acquired it.
Mala, acquired it, Mala, but they could not show a single document
No.
that when it was acquired, Mala, whether the payment has been made, and Mala, it is in my possession. And Mala, it has been, the report has come from the BLRO, Mala, based on, if your lordship kindly takes his report only, Mala, I'll rely on his report only.
No, you tell me the facts of the
Yes.
case. You
Mala,
answer your
lordship
matter.
will kindly takes, my lord. Yes. Mala, lordship will kindly takes my writ petition, Mala, first, Mala.
Yes.
Mala, page 29. It's annexure P3. Nah, I mean, writ petition.
Yes.
Mala, it's a order. The ordering portion is at page 34.
Yes.
Mala, the order was passed on 14th February 2011. Let affidavit of service filed today be kept on record. Since it has been submitted by the learned advocate for the petitioner that all the respondents, including the private respondents, have been served, he is directed to file affidavit of service by tomorrow. In the writ petition, the petitioner stated to be the owner of the land in view of the certificate of mutation being annexed at P1 to the writ petition has challenged the memo dated 28 June 2010 issued by the Joint Secretary of SPIOUD to the Government of West Bengal, Urban Development Department, Nagaland, the respondent number 2 on the ground that it is evident from the memo dated 19th March 2010 which has been annexed to the writ petition and memo dated 17th January 2011, a copy of which has been furnished in the court today, that there is no proposal for acquiring the land in question. Let a copy of the memo dated 17 January 2011 issued by the Additional Land Acquisition Officer, non-24 Parganas, the respondent number 7 be kept on record. It is to be noted that an acquisition is to be made by the collector of the district concerned and not by the Urban Development Department, as evident from the memo dated 28 June 2010 issued by the respondent number 2. Since it is evident from the memo dated 19th March 2010 and 17 January 2011 issued by the respondent number 7 that there is no proposal for acquiring the land in question, no order need to be passed on the writ petition. So, my lord, 2011, my lord, the state appeared, and my lord, lordship can also see from the records, my lord. Well, I am also carrying the notification. If your lordship wants, I'm carrying the certificate copy. If your lordship wants, I'll definitely produce it. My lord, there is no acquisition. Now, my lord, again a second order came. That at page 39. We went for mutation now. Yes. Now, in this case, the state was represented by the junior standing council and the municipality was also represented. In the writ petition, the petitioner has prayed for a direction upon the authorities of the Bidhannagar municipality through its chairperson, the respondent number 7, to consider the application dated 26 February 2010 for mutating her name
and the representation dated so and so, and the reminder dated 22nd November 2011. Having heard the learned advocates for the parties and considering the facts and circumstances of the case, the writ petition is disposed of by directing the respondent number 7 to dispose of the application dated 26 February 2010 filed by the petitioner for mutation by passing a reasoned order to be communicated to the petition within 4 weeks from the date of the presenting of the certified copy. The state never objected, nor produced any documents in respect to the acquisition is concerned. Now, Lordship will kindly take page 41, Annexure P6. Yes, this is my RTI application in 2018. May I read for your Lordship, Malab?
Yes.
Yes.
Page?
Page 41. To the Joint Secretary, Urban Development and Municipal Affairs Department, Government of West Bengal. Information I have sought for by one Gauranga Mitra. Under the Right to Information Act, please inform me regarding CS DAG number 6256 corresponding to RS DAG number 4371. That is, I am claiming the ownership, my lord. CS Khotian number so and so to RS Khotian number so on, Mouja Krishnapur, total area of land 46 decimal, PS Rajarhat, North 24 Parganas, West Bengal. Whether the above mentioned land is under your department or not. If the above mentioned land is under your department, then kindly furnish me all the relevant documents like your allotment copy, acquisition gazette notification copy, declaration copy, award list, which was supplied by Land Acquisition Department, along with other relevant documents available as soon as possible. Now, Mala, in reply to that, Mala, Lordship will kindly see page 42.
Yes.
Mala, it is coming from Government of West Bengal, Urban Development and Municipal Affairs Department, Municipal Affairs. Now, Mala, Lordship will kindly seize from Deputy Secretary, Government of West Bengal to State Public Information, Bidhannagar Municipal Corporation. I am directed to transfer. Here is a copy of RTI application along with 19th February 2018, along with enclosures 6.3 of RTI Act 2005, with a request to provide the required information sought for therein to the applicant directly under Section 7.1 of the RTI Act 2005. Now, Mala, I'll pause it for a moment, Mala. When this transfer is made normally, as per Section 6.3 of the Right to Information Act, when the department doesn't have any documents, he normally
We don't go on Right to Information Act to decide the property.
No, I am on the question of whether UD has any document or not.
And this court particularly hardly relies on Right to Information.
I'll
we all know how these come.
Yeah, I'll not then forward my argument on that. Very well. Now,
I can also give you in writing that the land belongs to you.
But
this is how RTI is used.
Now, if this, subject to correction by your Lordship, probably this has come from the Deputy Secretary, Government of West Bengal. Very well. Now, what has happened, Lordship will kindly take page 44.
Yes.
The answer. Page 44. Information in respect to application of Gauranga Mitra, so and so. With reference to the above, this is to inform you that after verification of all relevant files, that the RS DAG number 4371 of Krishnapur Mouja, so and so Rajarhat is not involved for acquisition from this office. Lordship will kindly record this one. This is the document which is I have placed before the writ petition. Now, after that, what has happened, I have made a representation that is before your Lordship. Now, I will kindly takes the exception. Not exception. Was it? Now, Lordship will kindly take their report. The report filed by the state, then I will come to the exception.
Yes.
The report as filed by the state, Lordship will kindly takes internal page 4, paragraph 3. C. In reply, B, I'll be for continuity. In accordance with due diligence, this office vide so and so dated 26 June 2025 made a formal request to the BL and LRO for providing the present legal status of the aforementioned land, accompanied by supporting documents in order to resolve any lingering ambiguity pertaining to the title and ownership. In reply to so and so, BLRO has come with a letter affirmed on 15 July 2025 beyond all reasonable doubt that the land in question being DAG number 4371 measuring 2.76 acres and classified as bill stands as fully acquired government land, the said acquisition having been completed under case number D9 of 1956-57 and stands recorded permanently in the nature of urban development. Then, my lord, the details of the dag number has been given. Yes. My lord, they have relied, my lord, this document, but my lord, they have not relied on the D case. Nothing. Now, my lord, the annexures, lordship will kindly see what they have annexed. My lord, page 9 is their annexure first. Yes. My lord, this was a letter from the land manager in reference to the writ petition so and so. I am skipping the 4 lines. I am just coming on the main point. This was on 26 June 2025. You are requested to inform this office the exact location of the said property. This is very important, man. And make this office informed whether the said property is included in Salt Lake area, sector 1, 2, 3, 4, and 5, which is presently under Urban Development and Municipal Affairs Department. You again are requested to provide documentary evidence in support of your report regarding acquisition, if any, as the matter is under consideration of Honorable High Court, Calcutta. Now, my lord, what the document they are submitting at page 10. Yes. My lord, this is to the land manager. It was addressed by the BLN. In reference to the above mentioned memo number so and so, undersigned likes to inform you that the Moja Krishnapur JL number so and so is not finally published yet, and thus, as per available documents, it appears that plot bearing so and so classified as bill with an area of so and so are fully acquired with a case number so and so and under the name of Urban Development Department. Now, my lord, they have only produced at page 11 a possession of the following plots of land having been received. My lord, there is nothing to show at least a document. My lord, no, I could not file any seal. I could not file any document. Nothing is there. Whether under which act it has been acquired, I should know first. Whether it's under Act 2 or Act 1, whether Section 3 was complied for requisition, Section 4 was complied, nothing, not a single document. Now, my lord, lordship kindly sees, my lord, what I am in my exception, my lord, how I have dealt with. I am not reading the paragraphs, it is there, my lord. Lordship will kindly take page 9 of my exception.
You know we are in writ petition, right?
Well, I am for the writ petition.
You know this is a writ petition, right?
Yes, man. I am now, only yes. What has fallen from your lordship? May I clarify one situation, if today they don't want to get
not holding the determination of suit.
No, that I have understood.
The writ court.
Only 2 things. If I can correctly, answer your lordship's query, এক second. If I can correctly, this is I have applied for mutation, if they grant it or not grant it, that's a separate. If they are coming with a document that this is an acquired land, at least they should produce some documents so that I can
civil court, file your case, get your title.
Today, what has happened, today your lordship knows, if they have taken my land, they have to prove that possession. I am in possession because they have served me a notice for unauthorized public
premises. It is enough for me to dismiss your writ petition.
May I, this is not a disputed
question of fact.
Then lordship, he is the state, at least some document may be produced.
Go file a suit.
Today,
disputed question of fact, they have said their affidavit is enough to dismiss it.
Lordship will kindly takes my exception once, then lordship decides.
Yes.
Lordship will kindly takes my exception. Page 9, I have just what I have tried to show, this is this is the letter addressed to from the additional district magistrate and district land and land reforms officer. With reference to the above, this is to bring to your kind notice that on basis of verification of overlapping register lying with the office by head survey and authenticated by OC, conversion section so and so, it appears the involvement of CS plot number 6256 correspondence to so and so proceeding may not be affirmed as desired documents are not readily available due to torn condition of relevant pages of overlapping register. However, a report has been received from the OC Newtown so and so as the plot is situated in Moja Krishnapur, and yet it appears that said plot is not involved in Newtown project Rajarhat. It is also specific finding of the this has been forwarded from the acquisition department. Now, at page 11, lordship will kindly see, yes. Now, I am paying the tax that I have. One of my adjacent owner, in respect to the self-same land, because it's a big land, we are paying the tax. We have annexed page 13 to 15, we have, and this is the BLRO report at page 17, Lordship will kindly take this,
Well, I am only on the basis of the report. Lordship will kindly see Shivnath Mondol.
Today, the corporation can't carry out the mutation if there's a
The
dispute.
corporation can carry out, but I humbly pray there is, I'm not on that. Then if the state comes with a
If you're
different
not with that, then go to the civil suit,
No,
file a
Malad-
civil suit,
Lordship will
get
kindly
whatever
takes.
right you have,
Well, I have a right.
put all your documents, file a suit for declaration.
Only I am praying before your Lordship.
declaring you to be the owner of the property.
Before your Lordship, proceed. I'll take your Lordship's 2 minutes of time. But today I have come before your Lordship for a mutation.
Yes.
But it is a state's case for the first time because it's a third round of litigation. The state on 3 occasions said, no, this is not an acquired land. Even the acquisition department has said, no, it's an acquired land. Well, they are coming with a document, may I ask?
Declaration, sir.
Malad?
File a suit for declaration.
If today, if
Then get a decree and go to the corporation, get the mutation done.
Suit that's a
Today with disputed question of fact, neither this writ court can help you nor the corporation can.
it is not a disputed. Why? Because they are coming with a document. 51, 57, they are showing the record. Am I not entitled to see the records, for the first time they are coming with the plea. If they have taken this plea earlier, and Lordship knows, UD is a department who can only acquire land after the land acquisition department has sent them. Otherwise, it cannot be done. Land acquisition department is saying, no, I have not acquired. How can UD can have the control of the land? But that is the fundamental question I am taking before your Lordship, BLRO is the custodian of records. He doesn't decide on the acquisition. Acquisition has to be decided by the learned officer.
Have you taken a, Mr. Nag, have you taken a decision on the representation, the mutation application?
No, Milord.
You have not.
We have.
You should have just
Milord, the difficulty for taking a decision on the mutation application is we have to go into issues of facts which is beyond.
No, you are not. You, till the time somebody is not able to show his right over the property, you can dismiss it. You can just reject the application.
Milord, maybe, Milord, but only one thing, Milord. Now, as the state has come up on record on affidavit saying that they have acquired the land.
Yes.
Even if Milord sends it for us for consideration, we will not.
Now I'll decide it.
Yes, we will not be able to go beyond the affidavit.
Or anything else?
Only 2 points. Let the state also say under which act they have acquired. That is also not specific. At least the gazette notification I am entitled, Lordship knows. At least this is the basic document the state should produce. Under which act and whether any payment has been made to the landowners.
All right.
Perhaps even if there is a gazette notification and no payment is being made, perhaps, Milord, that cannot be considered in this court in this juncture.
No, I am not considering on this.
You have filed your reply?
No, Milord. Here, Milord, we have nothing to say.
Another point, Lordship will kindly records, at my exception, I have annexed a document. Lordship will kindly takes once, that is at page 18. This notice I have been served. This notice I have been served during the pendency of the writ petition. Only I am seeking before your Lordship, the possession is with me. This is an admitted position. So, in the meantime, I may not, I will protected my possession.
Not at all. You have not filed a writ petition for this. You have filed a writ petition.
Today they have coming with all these things.
Challenge it.
I'll definitely challenge it.
Do whatever you have to do.
And what has in page
for a protection for something which is not
page
even
19 and 20. Page 19 and 20.
This changes the entire scenario.
No, I am not on that, What they are trying
You
to
are
do
on
is,
that, sir. You are asking for mutation.
what they have done, Lordship has a vast experience. Lordship knows how this state has done. Today, without any document, they have come. I am on that.
Disputed question of fact. This is what is going to come. CAV. There's no question of any mutation. There's no question of any.
Another thing, last, humbly, submitting. Last point,
Sir, we are in writ petition, sir. We are not deciding your suit.
The state is also not confident in which plot they are going to. Lordship will kindly says page 19 and 20. Once they have.
You think I'll grant right to the state? Disputed or question of fact. Why should I even look into it? You should rather withdraw it and not take adverse findings from it. I'll give my findings.
Lordship will kindly record.
I'll give my findings. I'll give my findings, which will be good for you.
An interim order was there, so I'll be only because your Lordship passed that.
What interim order?
Not to create any there was
no interim order now.
Why?
Reserved.
Very good.
Obliged.
I'm for the private respondent number 5.
In this case, my lord, I am for the petitioner. The case is, my lord, that the petitioner shops, my lord, in the first floor, and the private respondent shop, my lord, on the ground floor, and there is a passage, my lord. And my lord, the private respondent installed the AC machine in front of my window, my showroom, my lord, first floor, and therefore, my lord, the air, hot air, my lord, has been passes through my windows. Therefore, and that I made an application before the, my lord, Habra municipality to take steps and to place to some other place. Otherwise, my lord, my showroom has not been running. This is my case, if you lordship, my lord. I made recommendation.
Lord, firstly, my lord, I have not received any mentioning notice. Secondly, my lord, this land, my lord, pertains to my lord Habra municipality, under the jurisdiction of Habra municipality. My lord, they have made a party, my lord, the commissioner of Kolkata Municipal Corporation.
That is,
You are the private respondent.
I'm the private respondent number 5.
Who's the, you are appearing for Abra?
State.
Who's appearing for Abra Municipal Corporation?
Lord, there has not been
Because,
made a
my lord,
party.
You have not made Habra Municipal
but
Corporation?
my lord, that is a transfer body, my lord, if you lordship. My lord, I am.
And now, my lord, he is arguing the matter, my lord.
Recommendation was page 15, my lord, if you lordship.
I said, first make them a party. What?
Yes, my lord, if you lordship. Yes, lord, I shall liberty, my lord, to include the party of Habra municipality.
Without incorporating the party, my lord, he cannot argue the matter, my lord.
You are seeking your relief against which corporation?
That is Habra municipality, if you
Is,
but wrongly, my lord.
Wait a minute. Are they a party here?
No, my lord.
Then
But
why are you arguing the matter?
But if you lordship, my lord, made recommendation before the Howrah municipality, that's why, my lord, liberty, my lord, to include the name of the Howrah
Did
municipality
you seek the
in the
liberty?
petition.
Did you seek the liberty, sir?
If you lordship.
You started arguing the matter.
Yes, my lord, if you lordship.
Have you sought the liberty to
Yes.
plead Habra Municipal Corporation a party respondent?
Yes, my lord, if you lordship.
You already started arguing the matter as if they are already a
That
party
is the
here.
fact. I am stating the facts, if you lordship.
Why are you stating the fact when the respondent is not here?
Yes,
Answering
my lord, if you
respondent.
lordship. Kindly, my lord, liberty to my lord to make.
Learned counsel for the petitioner states that he has not impleaded Habra Municipal Corporation. The necessary party against whom the petitioner is seeking relief as a party respondent. Full stop. He prays and is granted liberty to make Habra Municipal Corporation a party respondent to the presented petition.
At once, my lord.
Let this matter be listed after, give after vacation.
Yes.
Necessary steps shall be taken, list after vacation.
After vacation.
At number 3, my lord, I am asked to appear on behalf of the petitioner, my lord. Last occasion, state has stated that the Kamarati municipality did not produce the document of retirement and other documents.
Yes, yes, what are your instructions?
My lord, I have an observation, my lord, from the DPPG. The pension case in respect of Shomindranath Chatterjee is returned herewith along with the connected papers for the reasons stated below, with the request that you will kindly rectify the defects pointed out. What are the defects? PSA is requested to move UDMA department to obtain for regularization of service during 7/6/2006 to 2009, which was already condoned by the previous Board of Councillors, my lord, and also by the DLB. My lord, previously also I gave him this copy.
Yes, Mr. Bari. Yes, so then why you are not releasing?
But he is not returning back the file. He has condoned. But after condoning, he has to return the file to the DPPG for issuing the pension payment order.
Heard
He has not returned back.
We'll pass an order.
He has not returned back the file to the DPPG.
This is what you do to your employees. You just make them run from pillar to post.
Can you
Not
see this memo? After this memo, they have not returned back the file.
saying that they have returned the file.
No. They are saying they have condoned only. Well, can you let them say that they have returned back the file? They have
Unnecessarily,
condoned, but they have
we
not
are,
returned back.
we are tired of We are absolutely tired of you.
Well, that's why you also direct him to show the documents that you have returned
Just
back the file.
PPO, my lord.
Let them show that they have returned back the file. I'm only on that.
It is given over
Let them
here.
show.
See that. The noting is there.
Document.
See that the
This
page
is my document
is-
which I sent it back to the municipality. Now it's his duty to return it back to the government authority. They have not returned it back. Let them show a document that they have returned it back. Only I am asking for this document.
My lord, we have sent the papers to the UDMA. My lord, for getting that condonation of delay.
So, madam, first you had sent the documents
Yes,
to
my
UDMA.
lord, they have sent us.
UDMA has sent it back to you. After that, have you sent it back to them? This is what he's asking.
Yes,
This instruction I have to take, my lord. I don't have.
This
that
is what you were
instruction.
supposed to take, madam.
UDMA didn't condone it, my lord.
They have condoned it. That's what he's saying.
No, we didn't get any instruction from the UDMA, my lord.
You find out.
Yes, my lord.
This is what yesterday also I told you.
Yes, my lord. হ্যাঁ, তো পাঠিয়ে দিয়েছি তো আমি।
Just find out if you have sent the documents or not. They are saying that they have condoned it. You have condoned it, Mr. Bari.
Yesterday also,
Madam, these are old documents.
on 29/7, my lord, we had released the
29/7 is July.
They didn't return, my lord.
That's what they're saying. They have returned it.
That I don't know. Do you have that copy that they have returned it? Do you have that
27 July it was sent to whom?
to UDMA? Because you had given us the on.
They're condoning the period. Well, they are supposed to send.
That's
the file to the
what they're
DPPG,
saying.
Director of Pension.
The instruction is the UDMA didn't condone
Hey,
it.
forget it. CAV. We'll pass an order. There's no point.
I'll kindly stipulated a time period for.
If you leave it to them, you'll be running from pillar to post.
I'll only kindly keep it this document only. Last time we send it to the authority formula, this document only. When we send it to the municipality for rectification, my lord. This was the last communication from the DPP.
In this, the replies have been filed.
Yes, my lord. Replies are already filed.
Yes,
Pleadings are complete, right?
yes, my lord.
All right.
Everything is filed.
We'll pass an order.
Deeply obliged, my
Just keep it on record.
Wait.
Keep going.
This is my affidavit service. I'm next. I don't want to get scolded from the court. Let me stitch it, then I'll file it. But there is a demolition order passed by the authority under the statute, but not implemented. That's the grievance.
Your Lordship, there is an order of demolition.
How come? Mr. Basu, you are here for this. What is the big deal?
Why my lord is envy of my.
No, I'm very happy to see you.
No,
Why should I be
happy to
envy?
see? But this type of matters, why you are happy?
Yes.
So, my lord,
Yes. Yes.
in younger days we have work hard, pay less.
So these days it's the other way around.
Usually, this is a normal thing so far as the lawyers are concerned.
Natural progression.
Less work and earn more.
Only one difficulty, Milord.
Yes, Mr. Khan.
I'm for the private respondent number 5. But
Yes.
suddenly the matter came up, Milord, without any notice. I called up again, Milord. I looked at it, Milord, yesterday night. I called my client, Milord, but his mother-in-law died, Milord, just 10 September. But the rituals have not been over. If your lordship takes up next week, so that I can take instruction. After a long time, the matter came up suddenly.
No, next week means there is a demolition order. You have not challenged it up till now anywhere.
Have you filed a appeal against the order?
My instruction is that G+1 there is a sanction. Thereafter, Milord, one additional floor were tried to be constructed, pillars erected. But after stop work, that was stopped. So that can be demolished. So far as regards G+1 is concerned, there are slight deviation found. But the prayer for regularization is pending before the corporation. The otherwise, the demolition order so far as regards the additional floor, I am not challenging. That additional floor can be.
Page 44 is our order, Your Lordship. It has defined and identified the nature of deviation. So, Your Lordship, there is an unauthorized area at the second floor, around 460 square feet, Your Lordship.
G+1 defeated, thereafter no sanction. And thereafter pillar has been raised.
Page 42 or 44, whichever Your Lordship may look into. So we had passed an order for self-demolition, which they possibly has not carried on. So if Your Lordship directs, we will.
So what are you doing since
What
then?
direction is necessary? Why you are not doing this?
We shall comply with our
We'll just record that. Let them file a report.
So far as regard, yes, Your Lordship.
Let them file a report.
So far, the additional flow, I am not even agitated.
The report means after demolition, let them file a report.
Yes, obviously,
After
action,
complying.
action taken report, let them file an action taken report.
Lord, so far as regards Your Lordship, kindly record my submission. G+1, the deviation which has been found, I paid for regularization, that is pending at their end. So far as regards additional flow, Lord, I am not even challenging.
Then we will dispose it of, Your Lordship. The prayer for regulation also will be.
Whatever you have to do, you should do it at your end.
That we will do.
This is my domestic house, it's not the multi-story building.
Take down the petition has preferred the present writ petition.
Your Lordship.
Being agreed by the yes
Yeah.
non-implementation of the demolition order dated 5/12/2022 passed by the assistant engineer in charge building department, Havra Municipal Corporation, in respect of premises number 260/5 Sarat Chatterjee Road, ward number 38, PS Shivpur, Havra, at the instance of private respondent. Full stop. Learned senior counsel for the petitioner, Mr. Basu, submits that this is the second round of litigation. Full stop. Earlier, the petitioner had preferred a writ petition 5424 of 2020 alleging unauthorized construction at the aforesaid premises. Full stop. By order dated 9/9/2022, this court directed the respondent to dispose of the petitioner's pending representation within a period of 1 month. Full stop. In pursuance of the said direction, the respondent authority conducted a joint inspection on 6/9/2022, and thereafter a hearing was held on 21/11/2022, culminating in passing of the self-demolition order dated 5/12/2022. Full stop. However, despite the same, the respondents have failed to act upon the same. Full stop. Agreed thereby, the petitioner has preferred the presented petition. Full stop. Learned counsel appearing for the respondent, Havra Municipal Corporation, submits that, seeks and is granted. How much time?
Lordship, 12 weeks.
12 weeks? 6 weeks to file an action taken report.
Lordship, in the meantime, there is vacations and all, Your Lordship.
All right.
Entire 1 month will go for the vacations and all. Puja vacations, then.
By puja vacation, you will not work.
Municipality closed.
Municipality
Then we are
closed.
gone. I am the
What
resident
happens
of that area.
What happens is, most of the officers.
From 2022, you have not taken any action.
Finally makes it 8 weeks.
3 years,
8 weeks.
8 weeks. Action taken report within 8 weeks. Full stop. Learned counsel for the private respondent submits that the alleged unauthorized construction on the first floor, that he has made a representation for regularization of the alleged unauthorized construction on the first floor, and the same is pending before the respondent municipality, respondent corporation. Full stop. Be that it may, learned counsel for the respondent, Havra Municipal Corporation, shall file an affidavit, action taken report indicating the compliance of the demolition order dated 5/12/2022. Full stop. List on affidavit of service taken on record. List on when do you want? After 8 weeks would be around 17th, 18th, 18th of November,
As forward us, only for compliance, so it is no hearing.
18th of
My lord was on Port Blair.
for 2 weeks.
2 weeks, yes, but complexion does not say so.
That's where I got my
That's why
cold cough.
I was not to me that my lord is in Port Blair, but after coming to the enter into course, I don't find my lord was in Port Blair.
But I've got that viral from Port Blair, I guess.
For the petition. Non-payment of pension and gratuity matter.
Not today. Yes.
Lord, I am for the petitioner. May I please be your lordship?
Lord, I am for the respondent number 7, private.
Yes.
Well, this is a matter relating to the unauthorized construction of a passage, common passage, ingress and egress of the petitioner of a local club. My lord, since August 2023, I am complaining before the municipality and also move 144 application. There also some orders are there, but in spite of that, the municipality are sitting tight over the issue and the local club are raising their construction. My first, my kindly comes to my first complaint as page 59. My lord, when I made complaint, the municipality has doing nothing and the district magistrate forwarded the copy to the local municipality chairman with the direction to do needful. But in spite of that, they are not taking any steps. My lord, thereafter, once again I made application and representation complaint before the municipality. Well, the page 67. Repeatedly I made representation. The facts of the case is, my lord, that my vendor's vendor, they have many properties around the area and make a deed of settlement. Father make a deed of settlement amongst the son, and in that deed, if your lordships comes to me, lord, my translated copy, which I have already handed over. That page 7 and 8, wherefrom it appears that it is a land near about 1 decimal land, which is common passage, the southern side of plot number, my lord, which is the disputed, which has
So this
local
history, this fight between you and
Yes, my lord.
somebody has been going on for ages.
Kindly comes to my translated copy, page 10. That is a map, Mauja map, my lord. I have annexed. The dispute between, my lord, I am residing plot number 977 and the local club occupy the property which is 974. In 974, southern side, 6 feet common passage are there since long. And the local club also occupying the land which they have no documents, nothing, no deed, nothing. They are occupying it. And they build up a 2-storied building. Now they completing near about completion, my lord, yet to be completed 3-storied building. At the time of they making 3-storied building, they occupy, encroach the 6 feet common passage, and there they making the staircase and that latrine. I object immediately after knowing the same. Repeatedly I made application and complaint before the municipality, but the municipality totally silent. There is no sanction plan, nothing. Why I am saying, my lord, the municipality is totally, rather they are collusion with the local club. At least from the record, I showing your lordships that 3 documents that how the municipality and local club are collusion with each other and they helping, rather the municipality helping to raise the construction. My lord, kindly, if your lordships comes, my first, my lord, example, I showing my lord, page 72 and 75, my lord, my RTI application and they reply. Well, my first point was, is there any sanction plan regarding the construction? And the answer is 74, 75, my lord. They are taking the point, it is a vague point, my lord, that 8.3, as per section 8.3, you are not entitled to get it. My lord, my lord, regarding 8.3, your lordships knows that is a 20 years back.
Sir, why are we getting into this? You go and these things should be challenged before the appropriate forum. You're only aggrieved by the 6 feet passage which is being encroached upon, right?
Yes, my lord, that is the common passage, which is the only ingress and egress of my house, my lord. That's why I raising complaint from August 2023, when they are starting. My lord, I am showing, my lord, your lordships will, if your lordships really see, your lordships will visualize the situation.
These
Well,
things you
this
should
is
annex here with the writ petition.
my lord, I have annexed but not colored copy. That's why, my lord, perhaps. This is, my lord, the number 1 is the material which is lying. That is the common passage, my lord. And that in right hand side, the clubhouse is there, 2-storied building. My lord, number 2 is that your lordships will see that the shade has already been removed of the clubhouse and the extension has been made. But number 3 is that already extension done and they are encroaching the 6 feet.
Where do you live?
Yes, my lord.
Your property is next, left hand side.
No, my lord, my property is, my lord, if your lordships translated copy, page.
No, in this picture, where are you? Where is your property?
My lord, I am showing, my lord,
From this picture, you tell me where is your property?
my lord, this is a very nearest place this photograph was done, and another photograph is there, my lord, where I showing your lordships. My lord, if the Mauja map is your lordship seen, then your lordships will visualize.
Please tell me from this picture, are you staying at the back? You're staying on the left, you're staying on the right. Where do you stay?
My lord, this common passage,
Yes,
through this common passage, in left hand side I reside. Through this common passage, but the multi-story building is there, my lord, the left hand side.
Yes.
After that multi-story building, the plot is there. Where my plot, I have purchased it in 85. My father purchased it. And there was a deed, well, settlement deed in the year 72. There it is written that there is a long dispute between the club and the local residents, and their resolution book, they written it, and that has been recorded in the deed, settlement deed 72, that has been solved. The club has already left this 6 feet common passage, and this is our possession. That has been recorded in the settlement deed. I have also annexed this and I have translated it for your lordships consumption. My lord, I have translated it. But the thing is the club and the municipality in repeated occasion, my lord, I am showing from the documents that they are sitting tight. The 144 application, the executive officer has directed to look into the matter. My lord, kindly comes to page. My lord, kindly comes to their 144 application. They moved. My lord, the Amitabh Bhattacharya, the then secretary of the club, they moved the application 144 in their.
Not a club.
My lord, kindly.
Sir.
They moved the application at page, my lord, 62. Kindly comes to your lordships, page 62. I am showing, my lord, the executive magistrate's order, my lord. My lord, the last paragraph. EO, Kamarhati Municipality Have your lordships got it? Page 62.
Yes.
My lord, the last paragraph. Executive officer, Kamarhati municipality is directed to cause an inquiry into the matter and submit a report by the next fixed date, and also to ensure that there is no violations of the existing municipal laws. Their direction. Thereafter, my lord, again, I move at 144 application, page 64, my lord. Another order. There also, it is recorded, the petitioner is filed the petition under section 144, which is being perused and considered. OC, IC, Belghoria, PS is directed to inquire into the matter and submit a report by the next date, fixed date, and OP number, OPR restrained from unlawfully constructing a bathroom and latrine on the common passage or doing any such unlawful acts of the disputed property possession of the petitioner. This is also direction, my lord, and jail number, Khutian number, plot number, and Kamarhati municipality also directed to cause inquiry in the matter. Well, repeatedly this has been done to stop, but the municipality are sitting tight over the issue. And in the meantime, they are totally encroaching, and my ingress and egress is totally, my lord, jeopardized. That is the point before your lordships. And if your lordships, the title deed, my lord, the settlement deed, I have annexed. I have translated, my lord. And the current record of rights, my lord, is the LR record. They are also in 974, plot number 974, which is the disputed plot, lying in the name of, my lord, the erstwhile owner who made the settlement deed. My lord, your lordships kindly comes to translated copy, my lord.
Sir, we are not deciding your title suit.
No, my
We are
lord, I am only
concerned
grievance
about
against the municipality, my lord. Municipality, if take steps in the proper time, then, my lord, it could have otherwise.
Very good.
They have no plan, nothing. Kindly, my lord, direct them to show the plan, sanction plan, nothing. No paper of the club.
All right. Yes.
First of all, my lord, this is not a club. This is a organization which are carrying on with festival. I mean, some traditional pujas, religious pujas and all. First of all, next thing, my lord, what he is submitting, my learned friend is submitting that it is he is getting obstructed by the ingress and ingress.
You file
My lord,
a
he
reply.
does not-
File a
if
file a
this is
reply.
the report, my lord, I have already gotten a report.
File a affidavit. File a affidavit in opposition. Forget about this report. Take down. The petitioner.
Well, in the meantime, my lord, kindly.
The learned friend repeatedly telling that it is a club. It is more than 100 years. Devayaton Sangrakhan Samiti.
Yes.
Durga Puja festival, Milord, this is a big building upon 10 kathas of land. 100 years traditional pujas are held here.
That's why, my lord, all these things are going on,
Not
my
a
lord.
All right, take down. The petitioner has preferred the present writ petition, challenging the inaction on part of the respondent authorities in not taking any steps to demolish the unauthorized construction alleged to be raised at jail number 3 at Mausa, Belghoria, jail number 3, Tausi number 172, LR plot number 974 under Baranagar, district 24 North Parganas at the instance of respondent number 7 and 8. Full stop. It is the case of the petitioner that he is the owner of the adjacent plot of land, LR plot number 977, under Baranagar, district 24 North 24 Parganas. Full stop.
It's under Belghoria.
The petitioner states that the private respondent number 7 to 8 is raising illegal and unauthorized construction at the said plot, encroaching upon the 6 feet common passage located on the southern side of LR plot number 974, full stop. Petitioner also states that they had preferred a MP case number 3860 of 2023 under section 144(2) of CRPC before the executive magistrate, full stop. He further states that despite what any order was passed there?
Yes, my lord, that restelling.
So and so, full stop. Learned counsel for the petitioner further states that despite various representation being made before the respondent authority, no action has been taken, full stop. Learned counsel for the respondent, which municipality is this?
Kamarhati municipality.
Kamarhati municipality seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter. List after 12 weeks.
My lord, status quo. At least,
No status quo.
my lord,
Let them enjoy the Durga Puja.
I'm grateful.
You want to file your reply, Mr. The private respondent? Learned counsel for the Mahabitalo, learned counsel for the respondent number 7 and 8, private respondent number 7 and 8, seeks and is granted 4 weeks time to file affidavit in opposition. Reply to the same, if any, within 2
And
weeks
my lord,
thereafter.
reply also, my lord, I have,
Not Voronezh, it's Belgaria.
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 well, I also, my lord, filed to reply, my lord.
I have already stated so.
I'm not.
12th December, 10th December. Give it 23rd December.
23rd?
23rd December.
23rd December.
My lord,
Oh, nothing. These are all fights which have no head.
my lord, that is at the verge of the Xmas, my lord. Well, kindly,
Let
1
them
week
enjoy the Christmas also.
my lord, 1 week, my lord. Before 1 week, my lord.
Or give it 1 week before that.
Before solo tolo.
So you are fighting for ages.
My lord,
All
that
these
is, my lord,
fights
I try my level best, my
all
lord,
your
to
civil
restrain them.
suits, you bring it, give it a color of, writ petition and try to bring it here.
My lord, I tried my
All
level best to
private
restrain. My
disputes
ingress and
must be
egress
tried.
totally, my lord.
This is the only ingress you have,
My
right?
lord, the other ingress egress is, my lord,
Keep fighting.
my lord, it is
How old are you?
My lord,
How old are you? Not you, means your client. How old is your client?
how?
Old is your client?
Old. My lord, my lord, his father has just died sometimes
Father
ago.
was, who started
Father
the
was the
litigation?
owner, then the son. Son, my lord, I think it is 55 or 57.
Father started the litigation.
No, my lord, father, at the time of father, my lord, it has not been there.
No litigation.
No, my lord.
Father was
But
reasonable.
at that point of time, that has not been obstructed. It is 2023. They are starting obstruction. That's why, my lord.
Secretary of the university.
You again make him the secretary.
My lord, it is a society.
Make him secretary.
10 years back,
Again make him secretary.
the executive member of the.
Sir, you vote for him, make him secretary. Make the son also secretary. All this litigation will go away.
My lord, the passage has been blocked totally. That's why, my lord.
No, once you
Otherwise-
become secretary, passage will be open.
No, my lord, he is the secretary and he is the, my lord, the one of the executive of the Kamarhati municipality. That is why
That
all
is
this.
what is troubling you.
Yes, my
You
lord.
make him secretary, all the trouble will go away. Next.
Translated copy টা রেখে দাও। Translated copy দিয়েছো। And it's some protection, my lord.
Give him around 8. No. Protection.
But then they are completing everything.
16th.
16th.
My lord, in this matter, I am on behalf of the petitioner.
My lord, in this matter, I am for the state. My lord,
I am for the Barampur municipality.
my lord, my lord, I find, my lord, the municipality had used an affidavit, my lord. I have been not favored with a copy of that, my lord. May I get that and come back tomorrow? Tomorrow, my lord. I will not take more time, my lord. Only tomorrow. They have used an affidavit. I have not been favored with that, my lord.
What is this?
post facto approval.
My lord, in this matter,
No, I have not got a copy, my lord. I have to take instruction from the department, my lord. No, only a 1 day question. my lord.
Covered matter. All right, Friday.
No, today there is a holiday in the departments. We are not.
Friday.
Friday. Well, kindly ask them to provide a copy, my lord. Only copy.
Give a copy. Friday.
My lord.
Unnecessarily, all these
Sure,
people are being, and give them money before Durga
no
Puja.
provisional
They're not getting
pension
any
also
pay.
not given, my lord.
At least provisional pension should be paid.
My lord, it will, my lord.
Nothing is being paid to
Let
them.
me
How
go
do they survive?
my lord, let me go through it. I will, my lord. I try my best. my
And
lord.
these are people who have worked for 30 years. You don't give them even provisional pension. Not even 4,000, 5,000 rupees is being paid. Please have some heart.
Well, I will, my lord. Take care of that. my lord.
Friday.
Thank you, lord. Grateful to you. sir.
Deeply obliged, my lord.
I am appearing on behalf of the respondent municipality, Lordship.
My lord, I'm appearing on behalf of,
Please.
I'm appearing on behalf of the petitioner, my lord.
Yes.
My lord, the petitioner is a retired employee of Chapdani municipality, my lord. After retirement, the PPO has been issued, but my lord, she was not receiving any retirement benefits. But my lord, after filing the writ petition, she received the entire gratuity amount, but currently she is not receiving his 4 months pension. She has not received
Lordship,
her 4 months
please
pension.
grant us some time, 2 or 3 months time, Lordship. We shall
So
see.
she has received gratuity at least.
Yes, my lord.
Very good. At least something has come.
My lord, but like she's
Pension.
poor, my lord. Like if the pension is,
Give the pension also now.
Lordship, Lordship,
kindly
kindly grant
direct-
us some time. We shall see.
my lord, kindly
State on the
direct-
petitioner has preferred the present writ petition, seeking a direction upon the respondent municipality to release her arrears of pension and gratuity amounting to rupees 4,55,774 that you have received,
Yes, ma'am.
together with interest at the rate of 7% per annum. Full stop. The case of the petitioner is that she was appointed as a conservancy worker under the respondent municipality in the year 1999 and retired from the service on 31/12/2023. Full stop. Pursuant thereto, a PPO was issued on 29/1/2024, granting pension and other retirement benefits with effect from
My lord, kindly direct the respondent authorities to.
wait a minute, 1/1/2024, full stop. As per the PPO, the petitioner is entitled to a gratuity of rupees 4,55,774 and monthly basic pension of 17,550. Full stop. Learned counsel for the petitioner states that after filing of the present writ petition, she has received the entire gratuity amount. Full stop. She further states that though she has not received the pension for the past 4 months.
4 months.
Full stop. Learned counsel for the respondent seeks and is granted. How much time?
Lordship, 3 months. 3 months time, Lordship.
Take instruction. Seeks and is granted time to take instruction. Let this matter be listed. When do you want?
Next week, Monday.
Next week. Next week, Wednesday.
Wednesday.
Take instruction, we can dispose it off.
Grateful.
Affidavit of service taken out.
Grateful notes.
Yes.
I appear on behalf of the petitioner. Lordship, 500 pensioners of the Bhatpara municipality are not being paid their pension. Lordship, currently as on date, Lordship, it is due from July 2025.
Yes.
Lordship, let them pay their arrears before Puja's, Lordship, so that we can fight it out the rest of the writ petition thereafter.
That is for them. Yes.
So far as this writ petition.
You are for the state.
Yes, no, I am for the
state.
municipality.
Municipality, yes.
Lordship, so far as the lease of this litigation, that is over. He said that he did not get it. He cannot keep the meter pending to activate the municipality. I understand that till June, he admitted. Last day I said.
Lordship,
then
let it be
Lordship
heard
said-
today. I do not want to keep it pending.
Yes.
Lordship, this writ
What is the
petition was
subject matter of
instituted at the juncture, Lordship, when the pension was due from November 2024. Lordship, in 3 installments, Lordship, the pension up to June 2025 has been paid.
Lordship, I prayed for a direction upon the municipality so that the pension is released within a specified date in terms of the rules of the state government, which specifies that the pension is to be paid by the last day of the said month. Lordship, as on date, Lordship, it is due from July 2025. No, Lordship, they have not paid. Lordship, the entire chart is there, Lordship. Lordship, kindly sees, Lordship.
No, this, the tenor of the writ petition.
Yes, page 35. Page 35, Lordship. Lordship, page 35, 36 is the detailed chart of the delay in pension since 2016 up to the filing of the writ petition. Actually, a habitual defaulter, the Bhatpara municipality. Actually, we are pensioners of the municipality. We need to survive only on the pension, Lordship. So, Lordship, timely disbursal of the pension is a part of the right to life under Article 21 of the Constitution, Lordship. And Lordship, in their report, Lordship, they have admitted that those are due.
Pension has been paid till
June.
June.
Yes. Lordship, on 10th of September, Lordship, it has been paid up to June, Lordship. On 9th of September, April and May.
Let this matter be listed for hearing after vacation.
But Lordship, kindly see, I have a submission. Lordship, since I have made
Lordship,
some
the
payment,
current
whether the
dues-
writ petition will remain maintainable or not, because now the order is of the preemptory nature.
Lordship, let the current pension be paid, Lordship, before the
Paying the
pujas.
pension at least.
That Lordship, I personally endeavor, I spoke to the chairperson. Lordship, I assured your Lordship that I will do it. Whatever I could do, I have done. Now it's a debt trapped municipality.
Let's not get into that. The debt-ridden municipality and all that. Please ensure that whatever
I did it. I did it, Lordship, but so far as
we'll hear it after vacation.
Lordship, one line to that effect, Lordship. Lordship, the state has said that the entire years up to March 2026 has been disbursed to them. Lordship, from that amount only, Lordship, they can pay.
Learned Council for the municipality has stated that they have made payments till
June 2025.
June 2025 and assures this court that further pension payments will be released as expeditiously as possible.
As expeditiously as the fund is also available.
Lordship, for the entire area, Lordship, the state has released
We are-
the municipality.
No,
Lordship.
not-
That
tomorrow I will
only,
give hold on this assurance. Lordship, please do not record that.
Lordship, kindly
I have
before
said,
pujas, Lordship, so that they can also survive, Lordship.
Lordship, it will come on me personally. Please, I cannot bear them responsibility. Subject to
Lordship paid expeditiously, girl. Will be paid expeditiously.
Lordship, the
List,
government,
list for hearing 12th November.
Lordship, the government has released its entire part for
Sir, let's not get into that government disbursal of funds.
Lordship, our right to life is being hampered, Lordship. That's why, Lordship, I'm making that prayer on behalf of the 500 pensioners, Lordship.
So that is the reason why the pension is being paid also. This
Yes.
court has been very sensitive to your cause.
Lordship.
And
Lordship.
time and again, we have been passing
Lordship, I've seen
orders
that
in
yesterday
favor,
also.
yes,
Yes. I've
in
seen
all
that.
the matters.
Yes. That's why I say, my lord, kindly indicates that before puja so that
He
they will.
needs a strong
Yes,
monitor
Lordship.
so that I should not default.
And this is what I've impressed upon him also. And he has ensured, he had taken pains also to speak with the concerned persons to release the payment. And further also, he'll ensure whatever it is, please,
As far as puja is concerned, I will try. Definitely.
personally, please look into it so that the payment is released. Mr. Lari will look into it.
Body. I don't know.
Item 10, I beg to appear on
The petitioner, my lord. This is a case relating to non-payment of retirement benefit of a retirement retired employee. My lord,
Opposition, I already served, my lord.
my learned friend gave assurance at the time of moving of this application, and upon accepting the such assurance, a direction was given, and accordingly, only 1 lakh rupees has been released, my lord.
Happened, my lord, I have annexed one document, one line observation, if your lordship, my lord, record, it will serve all the, my lord, retired employees. Because what happened, my lord, 2006, 114, my lord, upon approval was given by the director of local bodies. From the retrospective date, that is 1990. But granting salary, my lord, was released from 2006. That's why backlog, my lord, 10 years, more than 10 years, we have to, my lord, pay gratuity and other thing. That's why, my lord, fund, my lord,
Now shortage of fund, in the meantime, part payment was made 1 lakh. His client received. My lord, my lord, says your lordship, my lord, let them, my lord, add the director of local bodies in this, my lord, petition, so that your lordship can observe that.
They are not a party here.
No.
No, local bodies is not
Only
required.
pension.
This is the withholding of pension by the municipality.
That will help.
And gratuity.
Every
And
retired person.
PPO was issued by the Director of Pension and Provident Fund. And Director of Pension has been made party of
এটা
this.
করে দাও না, সুবিধা হবে, সবার সুবিধা হবে। My lord will, my lord, give one direction or observation that will must serve everything, my lord. 114, my lord, appointment. That is backlog, my lord, 1990, but grant in salary, my lord, released from 2006. I have annexed the document. That's why, my lord, my lord, my humble submission before your lordship, let them, my lord, add the director of local bodies in this matter and let it appear after vacation.
But what is the point of having director local bodies? They have already granted the post facto approval for this.
So that is not disputed. Only
the only
fund.
thing which they were required for.
At present, my lord, fund is one shortage. That's why if observation is there, we can approach the, my lord, director of local bodies to release some, my lord, assistant or fund to provide the retired employees gratuity, my lord, matters. Nothing more.
Oh, that
Everything
you can,
admitted.
That you can
It is
do.
due.
That you can do without making director local bodies a party here.
Yes,
There's no
kindly, my lord, only one line observation is your
No, why
lordship,
should
my
I?
lord.
They are not party here. Why should I? You should.
But
do
the
it on your
director of pension is party, my lord.
own. You should do it on your own.
Because Director of Pension has issued the PPO, my lord.
That's
And
why,
he
my
is
lord.
authorized competent.
Do you want to file your exception to this?
What exception I should
Alright.
file, my lord?
CAV. I'll pass an order.
My lord.
I'll pass an order. CAV. Heard?
For puja, we, my lord, paid each retired employee 1 lakh towards the gratuity.
Not
out of 7
my lord, only my lord, 3 lakh is
even
due.
Provident Fund amount has been withheld, my lord.
Way you make payment, it looks like some.
You
You are doing some service to them.
Yes, sir. 6 lakh.
3 lakh is already payment. 4 lakh already paid. Out of
No,
7.
no, my lord. Gratuity and Provident Fund is withholding, my lord. Part of the Provident Fund and entire gratuity. That amounts in 7 lakh. Only 1 lakh rupees has been paid, my
It is admitted. We
lord.
are not disputing anything, my lord.
All right.
Only my lord knows the Bhatpara, Titagore and other my lord, municipality, their position. At present, my lord, fund position, my lord.
Fund
deeply
position, then you should, wind up all these
municipalities.
The state should simply wind up these municipalities. This can't be a ground of taking people services and not making the payment. This can't be a ground.
If it is not retrospective, then we shall pay the current.
How can you even make these submissions, that you don't have funds? Why are you using these people's services?
No, my lord.
And then you don't pay them. How will they survive?
Actually, my lord, they are, my lord, contextual service was there. My
Sir,
lord.
whatever it is, that's over now. That story is over.
That is over.
Lock, stock, barrel, that is over. Municipality has regularized them, make them the payment, you have used their services.
Sympathy and other thing, my lord,
Sympathy
because
is
they are
not
retired employee.
translating into monetary sympathy.
They are retired employee, they need money, my lord.
Sir, verbal sympathy should translate into financial sympathy. They should see the color.
Trying, my lord. We are trying our best, my lord. We are, my lord, arranging fund from the property tax. And nowadays, my lord, if jute mill, what is the position of the jute mill? He knows, my lord, the entire Titagore area, my lord, all the jute mill.
That's why I'm saying you should wind up these municipalities.
Or privatized.
Exactly. Privatize it.
I deeply appreciate.
Appearing on behalf of the petitioner, my lord.
I'll come back.
Number 3, I supposed to submit this order copy with lordship. You have made CAB, my lord, the order.
Item
number 3, my lord.
Item number 3. What is this?
Judgments passed by this honorable court. I am relying upon this. Only
Item number 3, madam. Yes.
My lord, item number 11, 12, 13 and 15, my lord, all these matters are similar, my lord, and against the same municipality. My lord, the petitioners are the retired employee of Bardwan municipality.
How much is the amount? Amount will differ, no?
My lord, I have
It up-
prepared a chart, my lord,
Yes.
of all the 4 matters.
All right, then you give that to me. Then I'll just dictate in one of them, and then those changes could be incorporated.
My lord,
Take down the petition has.
my lord, previously I have also have moved 12 matters, my lord. This is the order, my lord, passed by your lordship.
Give it. Same order कर लो. फिर ये chart से you have to amount वाला. Date of appointment, retirement, appointment, retirement, and amount. बाकी से. बस.
My lord, item number 14, I am for the applicant.
14, 11, 12, 13, 15.
11, 12, 13 and 15.
11, 12, 13 and 15. You appear for the municipality, right? You file your reply.
Affidavit from a report in from affidavit.
Yes.
Matter we can please mal on 10th November mal kindly mal earlier okay.
When is that in the other matters? What is the date?
My lord, sorry, my lord.
In the other matters, is there any date given?
Yes.
10th November.
10th November. We'll have the same date, 10th November. Report and exception.
I file the reply mail in all 16 matters.
You should. Facts are different.
My lord, I am appearing for on behalf of the petitioner. My lord, in this case, the
I
petitioner
am for
is the,
the respondent municipality, my lord.
Yes.
the
My
petitioner
lord,
is
this writ petition is totally misconceived, my lord. He has got the gratuity, he has got the area pension, he has got everything, my lord. He has suppressed the material fact, my lord.
Affidavit of service, my lord. My lord, actually, my lord, the total amount dues, my lord, as per the statement prepared by the municipality, my lord, that total area amount, my lord, 8 lakhs, 10 lakhs something. My lord, lordship kindly see the
8,68,547.
page 14.
Yes.
Chart prepared by the municipality.
Yes.
Out of this 10 lakh 68,000, my lord, I have received only, my lord, 2 lakhs and current pension. My lord, still, my lord, dues, my lord, 8 lakh 68,000, my lord.
My lord, I am
And my lord,
submitting
similar
before
order has
lordship,
been
my lord.
passed by my lords, my
All
lord.
right, you file your reply, Mr.
Yes,
Das.
my lord, what my landed pen has suppressed, my lord. He has received the
You
area
file your
pension.
reply.
Yes, yes. My lord, I will get my lord, I shall file. I shall file a report with the affidavit.
Yes.
My lord, the petitioner is present here, my lord. He knows, my lord, what amount he has received.
2022 he has received. And my lord, there is a Bengali document he did not translate.
Well, only 2 lakhs he has received gratuity, but he is submitting, my lord, he has received the entire amount.
The petitioner has preferred the present writ petition seeking a direction upon the respondent municipality to release arrears of pension and gratuity. Amount of rupees 8,68,547 together with interest at the rate of 7% per annum. Full stop. The case of the petitioner is that he was an employee of the respondent municipality and retired from service on 31/1/2020. Pursuant thereto, pension payment order was issued on 16/8/2022 granting pension and other retirement benefits with effect from 1/2/2020. As per the said PPO, the petitioner is entitled to gratuity of rupees. How much is the gratuity?
Gratuity amount is 7 lakh. Gross gratuity is 6,18,750. It reflects from PPO page
6
30.
lakhs, yes. 6 lakhs
18,750.
750. And monthly pension of 18,750. Full stop. While the petitioner states that he has been receiving his monthly pension, the gratuity amount as well as arrears of pension amounting to rupees 8,68,547 has not been released. Petitioner has made several representations. The same have, but no decision has been taken thereon till date. Full stop. Aggrieved thereby, the petitioner has preferred the present writ petition. Full stop. Learned counsel for the respondent seeks and is granted 2 weeks time to file his report by way of an affidavit, reply to the same if any, exception to the same if any within 1 week thereafter, list after 6 weeks.
Well, kindly record, my lord, that they have paid the entire amount as my learned friend submits, my lord.
Let them file the report.
Yes, I shall file report. Well, can it be possible to fix any date, mother? Any date?
Yes. 29th October.
Get him. Get him. But instead of 29th, first week of November, any date, mother. I will not be here.
First week
Any day.
Second week. 7th November.
Get him.
Lodge. But I'm for the private respondent number 5, 6, and 7.
I service.
But I am appearing for the municipal.
Okay. But the petitioner,
yes,
petitioner is the resident, a tenant in respect of the entire ground floor of 2 properties. Initially, it was 1 property, later partitioned. It became 2 premises numbers. My lord, I've been in occupation for the last 70 years. All of a sudden, I find bulldozer in front of my premises and a portion of the property is being, my lord, it is being demolished. My lord, later I discovered that there is a notice given to the owners under section 412 of the KMC Act. Lordship, I would invite your Lordship's attention to the provisions of law, my lord, 411 and 412. But it says that an opportunity of hearing at least is essential. But there is no recording what part should be demolished, and now they are planning to demolish everything. But in between there is something more. But there the landlords tried to evict me by an eviction proceeding. They could not succeed. Ultimately, that resulted in a dismissal of the suit. But thereafter, all these things have happened. Everything behind my back, I'm still in possession. But I have my machineries there. It was a business, printing business. But these, I can show my lord, my documents of possession.
First, you were showing me the KMC Act. What were you reading?
Kindly comes to 411.
Yes.
But in 411, Lordship would kindly find, if I am permitted to read, Malat 411 subsection 2. The municipal commissioner may, if it appears to him necessary so to do, cause a proper hoarding or fence or other means of protection to be put up at the expense of the owner of such wall or building for the safety of the public or the inmates thereof, and may, after giving them such notice as the municipal commissioner may think necessary, require the inmates of the building to vacate it. But I am on this. But I was never given any notice.
411 power to order removal of dangerous building.
Yes.
Yes.
But I was required to be given a notice at least, but that you vacate or otherwise it will fall upon you. Whatever. But now no opportunity was given to me at any point of time. But I want to cite two decisions, my lord, of this honorable court, if lordship would kindly consider. But and I would show the position that is there in the property. A portion had fallen down, admittedly. Apart from that, the rest portions are in order. But we do not know whether there is any report to that effect from the corporation authorities regarding the other portions which are in order, which can be repaired, which are repairable.
Yes.
Lordship would kindly see. Malad, there is a notice that I have annexed before your lordship, which I have got from one of the owners, that is page number 23. This I have got, Malad, on 30th of August 2025, not before that.
Yes.
But notice was not given to me. No opportunity of hearing given to me. But the landlord was forcibly trying to evict me. We had filed a suit before the Shialda court and got an order of injunction.
Yes.
But that is of no effect, I can understand, my lord, not to evict without the due process of law. My lord, this was the order passed by Shialda court. My lord, thereafter, my lord, kindly see the photograph that is before your lordship at page number 71. But we have given letters, notices to all authorities. But kindly see from the photographs itself, it would appear a portion, yes, that was in a extremely dilapidated condition, but the rest portion is in order. But the debris, under the debris, my machineries are now lying. This is not the scope of the law. It's a big property.
So which portion are you occupying? This has become completely dilapidated.
No, my lord. It was the entire ground floor, which has two parts. My lord, one part they have demolished, that would appear from the photograph itself at page 71. But under the debris are my machineries, everything, my stocks, everything. Now, my lord, the other part, lordship would find that is perhaps in order. The corporation.
Nothing looks in order from the picture, sir. Show me.
No, my lord,
which picture are you showing which is in order?
Kindly see, my lord, page 71.
Yes.
The photographs that are at the bottom two photographs.
Yes.
But the other portion of the building, that is perhaps in order, my lord. The beams there on which the property rests, those are in order. It's not in a dilapidated condition. I am in possession of that in the ground floor. And the portion that was absolutely in ruinous condition, that has been demolished. Judgment maker.
Yes.
But I would refer to two judgments. Lordship would kindly consider or ignore. ये नहीं सबको इधर रखो. Lordship, this is reported in. এটা একটু জজ সাহেবকে দেবেন, এক্সট্রা কপিজ উनको দে দো. এটা একটু জজ সাহেবকে দেবেন.
These are not available orders before the tribunal?
No. But I'm referring to 1992 volume 1 Calcutta Law Journal. This is page 389. Lordship, I'm referring to paragraph numbers 9, 10, 11 and 12.
Yes, please read.
Yes. Lordship, paragraph 9. Upon perusal of all the materials on record and considering the facts of the case in depth and in details and looking at the provisions of law as discussed above, this court is of the view that the instant case, The writ petitioner has practically practiced fraud upon this court. It is found by this court that the petitioner has deliberately suppressed the notices and proceedings before this court, and there is no effective service upon the private respondent before the actual orders were made affecting the right of a tenant. While the writ petitioner admittedly filed a civil suit for eviction of the respondent tenant, the petitioner has tried to make a shortcut way to achieve his object. The affidavit of service filed by the lawyer's clerk as to personal service is not found to be just and bona fide. It is not appreciated by this court that the writ petitioner would try to make out a case of service of by implication. Since the respondent is a tenant in respect of the portion of a property has been found to be contesting the civil suit, ought to have been informed properly to enable him to appear before this court for effective adjudication of the matter in dispute. This court has considered all the affidavits filed by the respective parties, and looking at the materials on record, the conscience of the court is shocked that the writ petitioner has tried to collide and conspire with the corporation authorities in order to evict a tenant, but by not going to the civil court, but by coming to the writ court, and to achieve the object by making a frivolous and misconceived assertion that the tenanted portion of the property should be demolished. This court specifically finds that no notice of the proceeding was either served upon by the writ petitioner or by the municipal corporation authorities upon the private respondents, if at any relevant and material point of time. If the property under the lease is destroyed by irresistible force or by act of God, the question is otherwise. But where a person practices fraud upon the court and by taking the aid of the court destroys a leasehold property, the affected portion of the court should not become affected person or the court should not become helpless. The court is aware of the provisions of Section 18 and 18A of the West Bengal Premises Tenancy Act. Section 18 thereof envisages inter alia as to how a tenant is entitled to restoration and compensation, where the landlord obtains delivery of possession of any premises from the tenant in pursuance of a decree. The building or rebuilding or additions and alterations are not commenced, or the premises are not occupied by the landlord or by any person whose benefit the premises are held, as the case may be, within 6 months from the date of vacation of the premises by such tenant, or the premises having been so occupied by the landlord or any person for whose benefit the premises are held, the controller may, on the application of such tenant, seek reliefs or to pay him such compensation as may be deemed adequate. Similarly, Section 18A provides restoration of tenancy where decree for recovery of possession is passed under Clause F of subsection 1 of 13. If the landlord refuse to deliver possession, the controller can direct the landlord to put such tenant in possession of such a premises or such part thereof as the controller may specify in his order within 14 days from the date of the order. It is thus evident that even if a case of a decree for eviction on the ground of building, rebuilding, and development, the right of the tenant is protected on obtaining back possession after the old building is destroyed and a new building is raised. The facts of the case are very much interesting in the instant case. Here the landlord has practiced fraud upon the court with the aid of the court, and pursuant thereto obtained police force and allowed the corporation authorities to demolish a portion of the premises comprising the tenanted portion. If it is proved that the tenant will be helpless and the court will be a mute observer. The writ court is essentially a court of equity. It grants relief to persons who come with clean hands and obtained equitable reliefs by obtaining powerful writ of the superior court in the manner as provided under the Constitution of India. If the court who has issued the writ finds that there has been an abuse of the process of law, the writ court should not feel hesitant to restore the possession of the property and direct the parties to get the status quo ante before passing the impugned order. The present petitioner tenant admittedly is in possession of a portion of the premises. This court is convinced that the writ petitioner obtained collusive support of the corporation authorities, and under the orders of the court, there is demolition of the tenanted portion in occupation of the respondent tenant by the corporation authorities with the help of police at the instance of the writ petitioner. There is no fault on the part of the respondent tenant. This court has considered all the aspects of the matter and finds sufficient merits in the contention of the respondent tenant to restore the tenanted portion and or cause status quo ante in respect of the property prior to such and such date.
Yes.
But there is another judgment, if my lord will kindly consider. This is division bench. Lordship. Paragraph 28 and paragraph 29.
Reference to
Yes. This is 2007, volume 1, CHN, page 620. 2007 1, CHN, page 620. Para 28 and 29. May I read it?
Yes.
Considering the entire aspect as discussed above, we feel that the order of the learned single judge should not be retained, and we must hold that the writ petitioner was not entitled to a question or to question the authority and propriety of the order impugned in the writ petition. The writ petitioner could have, in our considered view, approached the writ court for protection of their interest in the event of demolition. There has been also appropriate court under tenancy law to protect the tenants. The writ court could have also approached considering the urgency. Writ petitioners are, however, bent upon to have the order of the hearing officer set aside than to protect their own interest under the statute, which was, however, outside the judicial review, especially in writ petition. By the passage of time, the said building could withstand such tilting. Admittedly, there was no repair caused to the said building, at least not brought to our notice. Fortunately, no accident occurred in between. The order impugned in the writ petition was passed in April 2001. We would be approaching 2007 very shortly. We feel the corporation may review the situation once more. We, however, make it clear that the order of the hearing officer would remain, as no interference could be made by this court. The corporation, through their own agency, would examine the condition of the said building once more, and if they feel that the order of hearing officer needs any further variation, they may do so. This exercise must be done by the corporation after taking into account the experts' reports so disclosed in this proceeding, including the experts so appointed by the court. If the corporation feels that despite consideration of the order of the hearing officer needs no alteration and or variation, they may compel the owners, the appellants above named, demolition of the said building with immediate effect. Before demolition is caused, the owners, appellants must give an undertaking to the corporation. But the gist is this part.
Yes.
My lord, I was never given an opportunity, my lord. My lord, it is my contention that the portion of the property that is under my possession right now is repairable. It is not dilapidated, which would fall down any moment. Kindly protect my tenanted interest in the property, my lord. But this.
Yes, who appears for the
My lord, I am
corporation? Yes.
On 2nd August 2025, early morning, the building collapsed. 2 persons were seriously injured. It fell on a multi-story building nearby. Well, upon being informed immediately, the corporation engineers and officers went there, and my lord had to decide that the building has to be pulled down. Accordingly, my lord, a contractor was engaged, and my lord, the demolition proceeding is going.
Why didn't you serve them a notice?
So because there was no scope. There was no scope. Your lordship kindly see on 2nd August itself, it was done. And kindly consider, my lord, the provision of
What do you
section.
mean, sir, no scope?
Kindly allow me, my lord.
Yes.
Kindly, my lord, look into subsection 4 of section 411.
The emergent situation.
The emergent provision.
Yes.
Yes.
And my lord, this is a non-obstante clause, my lord. It is on the, my lord.
So this you have the demolition action you are taking.
Yes.
For a dilapidated building under 400.
Not
Wait a minute.
dilapidated because, my lord, it collapsed.
This is
Not
411 or 408.
411 subsection 4. Your lordship kindly see. 400 subsection 8 of section 400 matter relates to ongoing unauthorized construction. That, my lord, calls for demolition without notice. Kindly, my lord, consider subsection 4. It starts with a non-obstante clause, my lord, notwithstanding anything contained in the foregoing subsections, the municipal commissioner may forthwith or with notice as he thinks fit demolish, repair, or secure or cause to be demolished, repair, secure, and any such wall or building or the thing.
So there is a provision for notice, sir.
Yes. Notice was given to the owner.
You know it very well. Even in the suit, you were a party, a defendant.
But the suit, your lordship.
You were a defendant in the suit also.
I'm coming.
Maybe a former defendant, but you were a defendant.
I'm coming. When it
you
was,
know it very well. He's staying in the property.
When it was done, your lordship can see my learned friend has submitted that he could come to know only on 30th of August. Now your lordship will kindly come to the suit. The application for temporary injunction. Kindly come to that, my lord. But it starts from page 30.
Where is your report of the chief municipal architect,
I'm
town
just
planner?
handing over, my lord. The brief came to me yesterday.
Yes.
Yesterday itself, my lord, I tried, my lord, a short report. On that basis, I'll show. Kindly, my lord, now look. My lord, paragraph 12 and 13 at page 32. That when it was within their knowledge, it's not that they were not. My lord, it's God's grace that the 2 persons who were seriously injured, hospitalized, my lord, did not lose their life.
Who are those 2 people?
But those 2 people were passerby.
Passerby.
Yes.
Yes.
Your lordship will kindly come to paragraph 12.
Yes.
It is his knowledge, my lord, that thereafter on 2nd August 2025, the defendants number 1, 2, 3 started to demolish the first floor in which is in their occupation, so that the plaintiff would be compelled to vacate the suit property. Your lordship kindly see who are respondent number 1, 2, 3. It was not within our possession as such. We were not corporation was not occupying.
Yes.
The building is a very old one. For demolition of the first floor of the building, the defendant's rented property would be in danger condition and becomes insecure. The plaintiff's directors and the employees somehow registered the defendants from demolition of the building. That the defendants number 1, 2, 3 for the time being refrained themselves from demolition of the building, but threatened the directors of the employees of the plaintiff company that they would soon demolish the entire building to construct a multi-story building. But it's only government. Your lordship now kindly see that they do not have any knowledge. All on a sudden corporation went there. They had the knowledge that such accident took place. The building collapsed. It was within their knowledge. It was within their knowledge that on 2nd of August itself, my lord, the corporation people went there and started demolition. So it is not a fact that they could come to know. Well, notice for what purpose? Notice is what is there. Admittedly, my lords, on 2nd of August, they had the notice. They had the notice.
Show me the file.
Yes, my lord.
Show me the file, demolition file. Where's the department file?
Yes, my lord.
Show me the notice which have been served.
The notice is not right now.
Show me the report of the architect.
Yes, my lord. Urgent report, my lord. It is there.
Show me the notice first. Show me the notice which has been served to the owner.
Notice, my lord.
That is annexed.
My learned friend can show, my lord, it was served upon the
23.
I had the notice. The police authority has given the notice, my lord.
Who are you?
For the
Police.
It is out.
26. Hmm. এটা তো 412. And this is the notice, my lord, asking the occupants, my lord, to vacate the premises. What else? Yes, my lord. Now, under such circumstances, my lord, to protect the, my lord, from any accident, any passerby or any public or any injury, my lord, the corporation had to exercise its emergency power. And my lord, the corporation is the best adjudicator in this matter, in my humble submission. Your lordship will kindly consider this aspect. Now, your lordship will kindly see. He's, my lord, he has stated that his tenancy is there. Now, what sort of order was passed by the learned civil judge? Your lordship will kindly come to. No. Kindly come to, my lord. এটা নয়। এর আগে আছে। My lord, will kindly come to page 24. Yes. Kindly come to the last 2-3 lines. I am reading, my lord. Considering the urgency of the matter, the principal defendants are hereby restrained from evicting the plaintiffs from the suit property without due process of law till 24th of September 2025. So their tenancy right is secured. And my lord, since it is on urgent basis, it has come. But there is, if the building is there, and if it is there, my lord, the tenant do not have any better title than that the landlord. And kindly, the situation is this: but let the landlord secure his possession. In the event he succeeds in suit, it will be there. But my lord, at the cost of the people's life and risk, common people's life and risk, my lord, this building cannot be allowed to stand. Kindly see the report, my lord, has gone. What sort of building is this? And my lord, from photograph, your lordship will kindly see, my learned friend, which has annexed to the writ petition, your lordship will kindly see from page. গাছটা কোথায় গেল? বড় গাছটা ছবিটা। My lord, kindly come to page 72, bottom. Yes. At the bottom left hand side. Yes. Now kindly see the tree. It was there and its roots, my lord, naturally, my lord, has made the building completely insecure. And my lord, being a civic authority, my lord, the corporation should not and cannot allow, my lord, any running of risk to the lives of the common people.
Yes. For the 5, 6, and 7. I'm the landlord, some of the landlords, but the allegation is that as if we have colluded with the corporation, which Milord ultimately prompted the corporation to Milord demolish the building. That is the case, Milord, made out before your lordship, tried to be. Kindly takes up, Milord, page 61, his own, Milord, representation before the corporation. It starts. I will only apprise before your lordship, page 62, paragraph number 3. May I place? That on 2nd August 2025, a portion of the building such and such, Maniktola, collapsed. Thereafter, on 13th August 2025, Kolkata Municipal Corporation issued a notice under section 412. Now, this has been alleged to have been came to the knowledge on 30th August by the same paragraph. This is, Milord, the fact. So, 2nd of August, the collapsing of building, since he admittedly saying that he is the tenant, it is well within his knowledge. But the 30th August, they only came to learn about the notice of vacating, which was issued of 412. On the second, on the third itself, there was a paper publication both in English and Bengali newspaper that 2 kids and 5 passerby was seriously injured. The corporation authority has started commencing demolition work on 3rd of August, admittedly. Kindly takes up very cunningly. He has filed a suit when 29th of August and 30th of August, this order has been passed. Kindly takes up their plaint. It has been annexed, page 35. This has been filed before the trial court on 29th August. So all these things have admittedly happened prior to that. Second, building collapse. Third, corporation started commencing demolition program. If he is a good litigant came before the learned trial judge with clean hands, kindly takes up page 35, how he has canvassed his suit. He are the plaintiffs. The up to defendant number 6 is the principal defendant, who are the landlord. And Kolkata Municipal Corporation, he has alleged as arrayed as pro forma defendant, no relief claim. He has portrayed in his entirety of the plaint that I am disturbing his possession and he is a bona fide tenant.
Yes.
Nothing is being disclosed, about second or third commencement of this demolition proceeding by the corporation without notice. And he has moved an injunction on the basis of this plaint and averment. And what is the injunction? My learned senior friend already placed page 24. The court only protected his possession. This was passed on 29th of August. Immediately on the next day, from the heaven he came to know that yes, this notice has been served. So this is something that he has obtained an order behind the back before the learned trial court, showing that I am disturbing his possession. Kolkata Municipal Corporation purposively has been arrayed as pro forma defendant, no relief claim. Immediately when that injunction he has got, on the next day, he finds that yes, a notice has been issued, approaching before your lordship's court, saying that violating that order of injunction, these things have been happened.
When when was the demolition? When did you get to know about the demolition?
According to his own representation, on 2nd and 3rd onwards, the demolition program carried out.
Lordship would kindly see.
So this is the English newspaper on the next day, which has reported that 2 kids and 5 passerby was seriously injured. And this collapsing of building happened at the midnight. I am seriously disputing his possession also, he is a tenant in respect of 400 square feet. He now comes after demolition and collapsing of building, that entire ground floor is with him.
That is a civil suit.
That is the civil suit. I am not agitating. Kindly, vis-a-vis, your lordship has already noticed, my learned senior friend has placed section 411 for small a is a provision where this kind of emergent situation the corporation can come, and what the corporation has did. But this particular plaintiffs who have approached the learned trial court not in clean hands, not disclosing everything, what is the actual position of the matter, they only portrayed before the court that yes, it is my landlord who is disturbing my possession. Why they have not spelled out anything about the 2nd August incident, 3rd August incident, and thereafter this was going on. Why the corporation, I am asking this question to myself, why the corporation is purposively arrayed as pro forma defendant? No relief has been claimed against the corporation, because they knew if the corporation is being asked to come and answer, then everything will come out. What happened? They only, waited, an injunction ex parte has been obtained against the landlord. Immediately on the next day, as per them, they got to know everything, and thereafter approaching the writ court. This may not be used as a tool.
Yes. Who else is here?
And one position, this is the existing pillar. What my learned friend is saying, the rest portion will also collapse. Lord, his possession, his tenancy will be protected before the civil court. Nobody is disputing to that.
Existing.
The extent of tenancy also, my lord, can be taken care by the civil court. But this is my.
This is my lord the photographs which my lord which is
Who
my
are you?
limited condition of this building.
You are?
This point number 8. I am also the landlord. My lord, my premises is the condition of this building. Is not fit for the human habitation.
Yes. Nobody staying there, right?
Gotcha.
Nobody staying there.
Yes. But the portion that is all right, but I have my go down there.
Which is the portion which is all right, sir? I can't see any portion which is all right.
My lord will kindly turn to the photograph. But in the photograph, lordship will kindly see page 71.
Page 71 also, sir. None of the photograph shows.
But the photographs at the bottom, my lord.
Even at the bottom.
The portion that was not in order.
It's completely dilapidated.
But the portion that was not in order.
Yes.
That has been already demolished. These
Not
are
demolished, it has collapsed.
But first of all, it collapsed.
Yes.
Thereafter, it has been demolished.
All right.
But I never say that the building is safe and secure.
Only removal of debris.
My lord, only thing, my lord.
If the building is not safe and secured, sir, then whatever right you have as a tenant.
Not in entirety, my lord. Not in entirety.
From the photograph, it doesn't show.
But let the corporation conduct a survey, my lord. Let somebody.
Where is your architect report? Where have you filed?
I don't have any architect.
You file an architect report.
Lordship.
File a supplementary affidavit.
Lordship.
Because there is nothing to show that the building is safe and secured.
Yes.
Get
But
an
in the
architect.
meantime, my lord, I will do that. But the corporation authorities can also conduct an inquiry. But I have no difficulty.
They have already done whatever they had to do. There
Very
is
good. I will
already
do
a
that.
report.
I will do that, my lord. But in
Right.
the meantime, they should not demolish the portion.
It's already demolished.
No, my lord. The portion that is remaining.
You should have filed it, sir. There is nothing on record today to show that the building is safe and secured. You are yourself saying it's not safe and secured.
My lord, a portion. My lord, kindly see. This is a big property.
This is nothing. This is only to grab the property
Not at all.
and have your rights.
But this is a
secured.
big
Nothing
property.
else.
This is a big property.
It's a big
in
property. You are in which portion of the property?
Which,
400.
but I am in the.
What is your area which you occupy?
But I have
Where is your
shown
rent
it.
agreement?
Yes. I have shown
Where is
you
the rent
lordship.
agreement?
But I have the rent receipts, my lord.
But I do not know since.
But I'm showing that.
That's what my learned friend's client had.
But I'm showing that.
Page 18, portion of ground floor. He's saying his entirety of the ground floor. Page 18, kindly see.
My lord is putting a question to me, my lord.
There
Other
is-
side is
yes.
answering, my lord. Kindly see page 18. But this is the rent receipt given in the year. But 1957.
Yes.
This is a portion of the building. This consisted of the two portions. Initially, it was together.
What is the portion of the ground floor which you are
Yes.
occupying?
Yes.
It's just a portion of the ground floor,
Yes.
not the entire ground floor.
But a portion indicates it may be 200 square feet. It
So
may
that's
not-
what I'm asking you.
But I have to bring that report.
So you
for
bring
your
it. Nothing is on record.
But I will bring it. My lord, kindly.
You have filed a petition bereft of all material particulars.
My lord will kindly see. I have the rent receipt. Current rent receipt also.
Sir, you are not even able to show what is the area which you are occupying.
But I may show.
But I
Kindly
will
takes up
show.
page 19.
Just a minute.
My lord, there are two in this property. There are two tenancies.
Sir, whatsoever it is, I just want to know what is your area which you are occupying.
Yes, my lord. One portion of the tenancy shows 400 square feet.
Yes.
400 square.
Yes.
That is at page number 19.
At bottom
But
line.
that is unit value.
Yes.
Area,
400.
that shows 400 square feet.
Yes.
My lord, now kindly sees there are two portions in the building
Yes.
under two landlords.
Yes.
My lord, my learned friend appears for one set of landlords and there are other councils appearing for the other landlords.
Right.
My lord, all are now together to get the building, my lord, to come down.
They don't have to come down. The building has already fallen down on its own.
My lord, if that happens, my lord, kindly sees page
Is
21.
this report wrong?
My lord, kindly sees.
Has the building collapsed or not?
My lord, a portion has collapsed, my lord. I never dispute
Sir, you are
that.
not even able to show me the
My
portion
lord
which
will
is.
now kindly come.
You
to-
have not put an architect's report here.
Lordship will
There is
kindly-
nothing on record to show that the building is in a
Lordship,
good condition.
I bow down to that, my lord. Lordship will now kindly come to page number 21.
You want more people to die there.
No, my lord, that will never happen. Kindly come to page number 21 once.
Yes.
Matlab, these are rent bills issued in July 2025 by one set of landlords, and they say that the property is not habitable. But I am paying the rent, they are accepting it, and now before the court, they are saying it is not habitable, it has to be pulled down. But
They
how
don't have
would
to say anything, sir. The report itself says.
Lordship, kindly appoint somebody or kindly permits
For
me,
what?
Lord, but to inquire what is the condition of the building, my lord.
You should have done that. Why didn't you do it?
But we
They have come to the court.
But that
You are
is true,
making
my
a
lord.
statement.
But that is true, my lord. Lordship, kindly protect my rights, my lord. It's a property which is falling on me because of them.
Your right
because
is
of the
protected as far as the tenancy is concerned. Your right will be protected.
My lord, before
This is not a civil suit you have filed.
because of the Kolkata Municipal Corporation, they are doing acts.
Today you are challenging the demolition order which has been issued by Calcutta Municipal Corporation, stating that you have not been heard.
Yes.
Or a notice has not been given to you. I'll justify there's no need to give any notice to you.
But I would be requesting your lordship, my lord, kindly protect in accordance with law whatever protection I am entitled.
The protection which you have is as far as the civil suit is concerned. You have your 400
But
or
even
whatever.
then, that has to be ascertained very well, my lord. I
Whatever
am
it
not
is.
standing in the way.
Whatever
My lord,
it is.
my lord, for the moment, my lord, the corporation should conduct a survey in the property. But I'm not standing in the way.
Why should they conduct a survey, sir?
My lord, in order to ascertain.
In order to ascertain what?
But what is the position of the property one?
Why you have not done that? That's exactly what I'm asking
That
you.
is what, my lord, the very day we get to know this, we approach your lordship. My lord, the corporation, we have given a
The
representation.
very day you get to know this is 2nd of August when the building has collapsed partially.
No, my lord, that this is incorrect statement from them, my lord. It was a portion of the first floor. It is indicated
Sir,
here.
none of your pictures actually show anything which can actually give this impression to the court that the building is in a sound condition. You yourself state that the building is not habitable.
But a portion of the building is.
Which portion, sir? From the picture
But
only.
the portion
Nothing is here on record to
But
show that.
Yes, my lord, the portion that has been pulled down by the corporation, that was inhabitable. But the portion which is still remaining today.
After lunch.
Huh?
We'll have it out.
But may I come back, my
Is
lord?
that a portion
But
which has
may I
been
come
collapsed,
back?
how it can be pulled down by the corporation?
And
that
may I
portion?
come back with a report of the, my lord, an architect, my lord? If lordship will kindly allow me 1 or 2 days, my lord, I will come back with that.
You file a supplementary affidavit. I'm not staying anything. I'm not staying anything.
But in that
I'm
event,
not a party to any more deaths.
but in that event, my lord, the entire building would be pulled.
Let the building go. It deserves to go. I'm not a party to this. I'm not staying it.
But kindly keeps it tomorrow, my lord.
Tomorrow, not today, tomorrow.
But some kindly recording may kindly be there.
Tomorrow, nothing. Tomorrow. Day after tomorrow. Day after tomorrow. Tomorrow is Thursday. Day after tomorrow.
But your lordship kindly record at least, my lord, that I have
Yeah,
submitted the report. Is that recording should take place, my lord.
Give him back the report also.
this matter for urgency, my lord. It has to be
Tomorrow,
listed.
tomorrow.
If it can be listed tomorrow in a position where it can be taken up, my lord.
Mention it tomorrow, we'll see it.
Thank you very much.
Seventeen, my lord, I am for the petition, my lord.
Yes.
My lord, the petitioner, my lord, entered into a development agreement with a developer, and my lord got in paid us a substantial amount of consideration money, my lord. Although the agreement, my lord, the agreement for sale was not registered, and subsequently no deed of conveyance, my lord, was registered by the petitioner. Even so, my lord, the petitioner has paid a substantial amount of money and is in possession, my lord, of a particular flat, which is situated at the 5th floor of a building, my lord. Now, my lord, initially, there was an allegation that the 2 floors of the building, my lord, is illegal construction. The top 2 floors. Now, my lord, an order was passed.
Building is how many floors?
My lord, G+6. G+6. My lord, initially, my lord, an order was passed, my lord, by the special building officer.
So G+4 is valid sanction plan.
That is what, my lord, the order says. The special building plans, my lord, the special building officer's order says so. Now, my lord, the order was passed, my lord, by the special building officer directing demolition of the top 2 floors. My lord, against that, an appeal was preferred in the tribunal by the developer. And my lord, the order was passed, my lord, against the developer. My lord, the landowners and the petitioners, my lord, they were nowhere to be parties. Now, my lord, an appeal was preferred by the developer. The appeal went against the developer. Against that, the developer, my lord, came before this honorable court. My lord, lost before the learned single bench, my lord. My lord, before the division bench, my lord, kindly, my lord, takes up page 70.
Page 70.
Page 70, my lord, is the order of the division bench of this honorable court, my lord. Page 70, my lord, it starts. My lord, 73, my lord, is the, my lord, the effective portion, my lord. 73, my lord, second, my lord, may I read, my lord, for your lordship? Page 73 onwards.
Yes.
But in view of the aforesaid, my lord.
Yes.
My lord, may I start from page 72, my lord? Page 72.
Yes.
The short grievance, my lord, I'm reading from the 3rd paragraph. The short grievance of the appellants is that the tribunal and the learned single judge both relied heavily on the note report of the technical member. However, no copy of such report was made available to the appellant's writ petitioner. This is a flagrant breach of principle of natural justice. We have ascertained from the learned advocate representing the corporation that it is indeed a fact that the copy of such report of the technical member was not supplied to the appellants at any point of time. In view of the aforesaid, we are of the opinion that the principle of natural justice has been violated in the instant case. The note report of the technical member ought to have been supplied to the appellants, and they should have been afforded an opportunity of taking exception thereto for whatever it is worth. And in view of that, my lord, the last paragraph, my lord, I'm reading, in view of the aforesaid, we set aside the order of the learned single judge as also the order of the municipal building tribunal only on the ground of breach of principle of natural justice, and note on any point touching the and not on any point touching the merit of the case, we remand the matter to the municipal building tribunal to pass a fresh order after giving opportunity to the appellants herein to file an exception to the note report of the technical member, and after affording a reasonable opportunity of hearing to the appellants herein on their authorized representative. Now, my lord, after this, my lord, the matter was remanded back, my lord, to the learned tribunal. My lord, there, my lord, the difficulty arose. Lordship kindly takes up. My lord, page number 88 first. This is, my lord, the order of the learned tribunal. Page 88, my lord, the developer does not appear. Appellant takes no step. Learned advocate for the KMC is present. Private respondent number 4 is present and seeks to appoint an advocate. It appears that the appellant was directed to remain present as per order dated such and such. On repeated calls, no one appears on behalf of the appellant. It is now 2:55. In the circumstances, appellant is directed to show cause why the instant appeal shall not be dismissed for default. And my lord, kindly, my lord, comes to page 90.
Yes.
Well, at page 90 is, my lord, the appellant, again, my lord, does not show up. No, on repeated calls, none appears on behalf of the appellant, no causes is shown, and hence, my lord, the next page. The instant appeal being BT appeal number 83 of 2023, same is dismissed with cost of rupees 2000. Now, my lord, this happens on 4th of August 2025. Well, subsequently, I come to know of it. I am, my lord, one of the resident, my lord, in the top floor of the building. I come to know of it. My lord, I try to prefer an appeal against the order of the special building officer before the learned tribunal. Since, my lord, the appeal, my lord, the developer in the instant case, my lord, does not take any step. My lord, my appeal is not registered before the tribunal, stating that the order of the special building officer that was passed against the developer and your name is not featuring in that appeal, in that order. My lord, kindly considers, along with the memo of appeal, I have also, my lord, tried to file an application for leave to prefer an appeal. Lordship, my lord, page 105, my lord kindly takes up. Page 105. Page 105, my lord, is my application to leave to prefer an my lord, appeal against that order. Since, my lord, the developer, my lord, does not come forward, my lord, after the remand was made, my lord, by this honorable court on particular points, my lord, the developer does not appear, my lord, before the tribunal. Hence, my lord, in today, my lord, the developer does not state, my lord, takes any step, my lord, I have to come forward, my lord. My lord, my innocuous prayer, my lord, before your lordship is, my lord, let, my lord, this appeal be registered and, my lord, heard out on merits.
Yes, Mr. Ghosh, you are appearing.
Admittedly,
He has to be heard.
what, my lord?
He should be heard.
No, there is no scope under the law. There is no scope under the law.
Whatever, they can dismiss it, but where will he go?
He can't go anywhere because he is the purchaser of unauthorizedly constructed property.
That's all right.
That, my lord, has not given any right to him. Who can prepare an appeal? That has been provided under the Act. And obviously, my lord, anybody comes to the court, he, my lord, is the owner or purchaser of the flat of the top floor. So that, my lord, the immediate below floor cannot be my lord, broken or demolished. This is the things, my lord, coming up to the court. Now the thing is, my lord, his legal right, he's claiming his right only on the basis of that purchase. And admittedly, that portion is unauthorized. Well, he is not saying that is an authorized portion. The 2 floors, my lord, absolutely unauthorized. Over and above, well, side open spaces have been covered. Entire side open spaces.
That the division bench also had said that even if it is unauthorized, the person has a right to be heard.
No, that, my lord, right, my lord,
That is for the
because, my lord, that was the proceeding was initiated. That order was passed division bench for a limited aspect, it was sent because the proceeding was initiated against a person who has, my lord, made the construction. And I am bound to, my lord, initiate the proceeding against a person who has causes the unauthorized construction. If your lordship kindly, because of that reason, because he is only right that I have purchased, therefore I can be permitted. But he does not acquire any right even to the property because of purchasing an unauthorized property. And also, my lord, because of the occupying in unauthorized portion. But this has been taken care of by the Honorable Court in number of cases. You logically see the provision, my lord, first.
Show me the judgment.
You logically first logically section, my lord, says, section, my lord, logically come to section 400.
KMC Act.
Yes, my lord. To whom I am to hear in a demolition proceeding. Section 400, subsection 1, you see.
Yes.
That will, after 3-4 lines, make an order directing that such erection or work shall be demolished by the person at whose instance the erection or the work has been commenced or is being carried carried on or has been completed within such period not being less than 5 days and more than 15 days from the date on which the copy of the order of demolition with a brief statement of the reasons therefore has been delivered to such person. Now logically similar the next, the person at whose instance has been explained by the statute that you lordship find, my lord, after the subsection 1. Explanation in this chapter, the person whose instance shall
Where are you
be.
reading, Mr. Bush? Where are you reading?
Well, first I have read, my lord, 400 subsection 1.
Yes.
That says that whose instance, my lord, the construction has been made.
Yes.
Well, that the person at whose instance that has been, my lord, explained by the statute at the immediate after the 401 section explanation, you also can see the explanation.
Yes.
After, my lord, the provisos of subsection 1. My lord, got it, my lord, explanation?
Yes.
Subsection above subsection 2.
Yes.
In this chapter, the person at whose instance shall mean the owner, occupier, or any other person who causes the erection of any building or execution of any work to be done in any alteration, if any, or does it by himself. But this is the issue was taken under consideration in some of the cases by this court. But I am just placing your body at whose instance who is to be heard in the proceeding under section 401, and that person's only, my lord, can prefer an appeal. That you logically find, my lord, section subsection 3. Any person aggrieved by the order of the municipal commissioner made by under subsection may within 30 days may prefer an appeal. The two issues have been considered by the Honorable Court in number of cases. If the proceedings to be initiated against the person at whose instance the construction has been raised, and that has been connected with the right to prefer an appeal with the causing of the unauthorized construction. The person who has some relation to the unauthorized construction.
What about 401A, the definition of person?
My lord?
401A.
401A.
The definition of explanation, persons.
That is relating to the proceeding, criminal proceeding.
That's right.
But that is that has got no connection with 400 proceeding.
So if a person can be charged with carrying on all this, then why can't he be heard?
Hello?
That is a criminal proceeding. Criminal proceeding is against persons who are responsible.
It is a
All
person
right?
responsible.
So responsible would also enlarge the scope of person to the extent of the occupier too.
No, that may not be. He must have some causes of the construction. If he has no connection with the construction works, he can't. Otherwise, my lord, the whole purpose and object of the act would be defeated. Whole purpose and object of the proceedings will be defeated totally.
Show me the judgment, Mr.
I know. Here you can see, my lord, this is single bench judgment. We are relied on, my lord, two, my lord, the division bench judgments of this honorable court.
Yes.
So the citation.
2006 2 CLJ Cal
16
6 2 CLJ Cal 574. And I had the occasion to argue the case that 20 years back, this judgment was delivered by the Honorable Court. And that too, relying on two division bench judgments of this Honorable Court.
20 years back.
Well, it is 2006, the judgment was delivered in 2006. Now we are 2025.
Yes, which portion are you reading?
Yellow sheet kindly straightway come 26 onwards.
Just.
Because the earlier act says about the person responsible. Now the word has been issued by the person at whose instance. The person responsible was used in 1951 Act.
This is a tenant, huh?
My
in this matter, the person was a tenant.
Tenant, occupier, whoever may be. The issue is, who has some connection with the construction works. expression person is responsible.
Just a minute, Mr. Bush.
My lord.
Yes. Yes.
This, my lord, the judgment came, my lord, after considering two, my lord, the judgment of the division bench judgment. And then one judgment is said, no right to property, my lord, derives, my lord, another's property.
Have you seen this judgment?
No, my lord. My lord, may I come back tomorrow, my lord?
Tomorrow is Thursday, not tomorrow.
Friday then, my lord, may I come?
Monday.
Monday.
You need more time. And give me a copy of that.
Yes, certainly, my lord. My lord, I've got the citation, my lord. I'll take it out.
You have other judgments also?
Well, there are other judgments too, my lord. The division bench judgment, recent judgments. In this case, my lord, followed the earlier two judgments, one of 1998 possibly, and thereafter, my lord, in.
See, what they are saying is that, counsel, what they are saying is that the owner, occupier, or any person who has carried out the construction will have a right to be heard.
My lord, only, my lord.
That is the only distinction. So they have given a restrictive meaning to the word any other person, which is restricted only to the owner, occupier, or the person responsible for carrying out the construction. It is not extended to a tenant who comes later on, or to a person who has purchased a property, in your case, a person who has purchased a property later on. So there's a restrictive meaning which they have given to 401. That is what the judgment says. Right, Mr. Ghosh?
But only thing is, my lord, in this case, my lord, my register.
I tell you, Lordship, my lord, otherwise, if this is, my lord, accepted, the whole purpose and object of the provision.
That's also
that entirely to be defeated.
That's
Where
also
today
quoted.
one person will come, next one another person will come. That is also my observed by the court.
Your argument is well taken care of in that.
I'm grateful to this honorable court that one would be accepted by this court. On the face of that, the seat, Mr. Pajai appeared. He was a renowned barrister of our.
Yes, we all know Mr. Panja.
And I could, my lord, I was satisfied rather when I found that the court has accepted my point.
Yes.
My lord, only thing is, my lord, my registration of appeal, my lord, my maintainability of appeal, my lord, comes after my registration. But in this case, my lord, my registration of appeal, my lord, that is being, my lord, restrained.
The registration of appeal is restrained because they don't find you to be the person responsible in any way.
My lord, in my humble submission, my lord, my lord, in my humble submission, my lord, any order, my lord, in any forum, my lord, a person is, my lord, entitled to register his appeal. After that, my lord, if the learned court, my lord, finds that the appeal is not maintainable at his, my lord, behest, the appeal goes.
So your application was also not listed before the tribunal.
My lord,
application also could not be listed.
No.
The registry itself denied you.
Yes. That is what my grievance is.
So did you mention it before the tribunal? The honorable members of the tribunal, did you mention the matter?
No.
You should have mentioned the matter before the honorable members of the tribunal.
Lordship, my lord, would be, my lord, then please to, my lord, grant me leave, my lord. So, in that case, my lord, I can.
You cannot have the blessing of this court, my lord.
I'm not granting any in accordance with law, whatever he wants to. You can withdraw it and move in accordance with law.
My lord, may I come back on Monday then, my lord?
Come back.
Come back on. Grateful.
But try to mention it before the tribunal there.
My lord, I'll do so.
You try to mention it and then see what happens. Not today, Monday.
If there is no appeal, then there will be suit. Person cannot be non-suited.
Correct.
File
a suit. He has a right to claim damages also.
Then there has to be interpretation that this suit will not be restricting the restriction of suit clause in KMC Act.
My lord.
It is better. The corporation will not be able to do anything. One injunction, 15 years. বলুন এবার এটা বলে অনেকদিন আপনারা চালান আমি জানি
think, my lord, they are developing the person who are taking another construction. Somebody is going to receive it and getting an injunction. That is also not restricted by this law. Because that is the whole process. You know, see, defeat the object and purpose of that.
That's true. Civil code granting an injunction, yes. Yes.
Here, my lord, this is my lord. Yes, I am challenging, my lord. I did. Of the, my lord, writ petition, my lord. May I just place it first and thereafter I will place the facts, my lord. Page 51 is the impugn, my lord. Reference to West Bengal. It is to inform you that the Principal Secretary Department
Yes,
of...
one second. Page 51, right?
Page 51.
Yes.
This is to inform you the Principal Secretary Department of Urban Development, Municipal Affairs, Government of West Bengal has passed an order wherein your prayer, quote unquote, to allow the change of purpose of usage of the aforesaid plot in question from automobile repairing shop, garage to other commercial purposes like shops and other commercial establishments, commercial institutions has been rejected. Whereas it has been found that you have been carrying on several commercial activities without any valid certificate of enlistment since long under section 141 as well as section 304 of the such and such act from the corporation and without approval of the change of usage of land pattern by the urban development and municipal authorities. Therefore, you are directed to close down all illegal commercial activities within 2 weeks from the receipt of the letter. Otherwise, corporation will say initiate appropriate action.
Yes.
Now, my lord, this particular plot of land was, my lord, leased out by the government.
It's a 23 notice. Why you're coming after so long?
It was challenged and 23 itself.
This was challenged.
Yes, writ petition is of 23.
Okay.
Now, my lord, this particular, my lord, they know why they have not taken action.
The first time it's coming up.
Yes, for the first time. They know that they have issued a, my lord, illegal notice. I demonstrated before the lordship. But this particular land was given to, my lord, my father, predecessor in interest,
Yes.
in lease from the government of West Bengal, which is regulated by the Urban Development Department. Clause 2.9 of the lease said that it has to be 2.9 is page 32E. In any case, I'll draw your lordships if required. Says that it's admitted that it has to be used for automobile repairing shop. This has to be done. Thereafter, my lord, in 1994 to 2001, I have constructed a 4-storied building. The completion certificates are there from page 32 to 35. And subsequently, what happened, the notification was issued by the government taking note of the fact that several lands in my lord Salt Lake were kept unutilized and therefore government allowed the change of usage by payment of fees. That is, the notifications are in 2005 and another notification was issued in 2008 saying that if a person has already converted his, he changed the nature of usage, he can give a 100% penalty and alter the nature of usage and the government will allow that. I made an application in 2016 for change of nature of usage saying that this particular plot of land, the entire character of the area has changed. The city center has come up. This cannot be now used as automobile repairing shop. So kindly consider my application in accordance with the notifications. They didn't do so. But however, from 2021, 2023, even recently also, they have been issuing trade licenses. Those form part of the record. Page 38, 39, 40. Recently, after filing this writ petition also, they have issued trade licenses. May I just, for a sample, place one trade license. Page 40 kindly comes. Or page 38. Any case, all languages are similar. Page 38, may I place? Board of Councillors of Bidhannagar Municipal Corporation hereby grant unto Manoj Kanti Sen Sharma, Balveer Singh Walia, the partners of such and such, residing at such and such, to carry on business at the holding premises number such and such, and to exercise profession, trading or calling of restaurants or eating house, or seller of food items. Eating house, stroke restaurant, stroke eating house, come restaurant, fast food center, such and such.
Now, my lord, these licenses have been now same license, page 39, in respect of the same premises, in respect of Bhaskar Dev being one of the petitioners. That was in previous, my lord. Thereafter, page 40. Subsequently, also they have issued. Now, my lord, with regard to my application in 2016, which I had made, saying that kindly allow to the Urban Development Department. Anything with regard to the lease is the Urban Development Department, and anything with regard to the implementation of 2006 Act, Municipality Corporation, the local authority. Now, my lord, that application of 2016 was kept pending. I had approached this Honorable Court. The Honorable Justice Debanshu Bosak was pleased to direct the authorities to consider my application. They didn't do so. They continued to issue, the Urban Development Department, they continued to issue show cause notices, saying that why you are using. There was an order directing them to consider, but they didn't consider, but they were issuing show cause. Challenging those show cause notices, I came up before this Honorable Court, kindly takes up the order at page 41, which summarizes everything. May I just place, this order is important. It is submitted, Lordship is there at page 41. It is submitted by the Learned Counsel appearing on behalf of the petitioner that the leasehold right of the plots in question granted in favor of predecessor of petitioners, Manjulal Dev, vide in indenture dated such and such, and after demise of the said lease, the petitioner being his legal heirs have stepped into the shoes as present lessees of the property. The petitioners raised construction in the property after obtaining sanction plan from the concerned authority and subsequently approached the concerned authority for permission for alter of usage of property in question in terms of the government notifications published in May 6, 2025 and May 6, 2008, respectively. Petitioner submitted a representation before the concerned authority in this regard on July 11, 2016, which was kept pending. The constituted attorney of the original lessee, Manjulal Dev, approached this Honorable Court in writ petition number such and such. By an order dated January 8, 2019, coordinate bench of this court directed the concerned authority to consider and decide the representation dated July 11, 2016 for change of usage in accordance with law after hearing the petitioner as well as the other necessary parties as deemed appropriately by the authority. The entire exercise was directed to be completed within a period of 6 weeks from the date of communication of the order. In the meantime, the predecessor of the petitioners approached the civil court in suit number such and such, and on prayer of the said predecessor, the learned civil court by an order dated November 3, 2016 granted an order of interim injunction in favor of the petitioners, restraining the concerned authority from giving effect or taking any coercive steps in view of the order dated February 25, 2017 and October 13, 2017 till December 12, 2017, the interim order being extended from time to time. The order under challenge in the civil suit was issued by the authority for demolition of the unauthorized construction allegedly made by the original lessee. It is submitted on behalf of the petitioners that the representation submitted by the petitioners was not disposed of in terms of the order of the court, and during pendency of such representation, a notice was issued. Notice was issued by the Joint Secretary, Government of West Bengal on October 31, 2018, alleging violation of the terms and conditions of the lease deed. In respect of the plot in question, the petitioners replied to the said notice and reiterated their contention as made out in the representation submitted earlier and dealt with in the specific clause of the show cause notice. During pendency of the representation as well as the earlier show cause notice, a second show cause notice was issued upon the petitioners on February 7, 2022, continuing in identical averments as in the first notice. Petitioners replied to the said notice without prejudice to their rights and contentions and have challenged the notices on the ground that they have been issued during the pendency of the representation, which is yet to be disposed of in compliance with the earlier order of this court. Thereafter, I am skipping, kindly comes to the ordering portion, next page. By an order dated January 8, 2019 in writ petition number such and such, coordinate bench of this court directed the Joint Secretary to the Government of West Bengal, Urban Development Department and Municipal Affairs to consider and dispose of the representation dated July 11, 2016 made by the original lessee within a stipulated time frame. It is not in dispute that the said representation is still pending. The representation was taken up for consideration by the Joint Secretary of the Government of West Bengal by an order dated such and such. Decision with regard to the same was kept pending, awaiting opinion of the Bidhannagar Municipal Corporation, in short BMC, and receipt of the required reports from the said authority. In the meantime, trade licenses were issued by the BMC in favor of the partners of Balle Balle Dhaba for running a restaurant in the premises in question till December 9, 2024. In view of the fact that the order of this court granted earlier was not being complied with by the respondents, and also that the representation submitted by the petitioners on July 11, 2016 is still pending, concerned authority is being the first respondent herein ought to have decided to considered and dispose of the representation within the stipulated time frame, and after giving reasonable opportunity of hearing to all the stakeholders, including the petitioners, and upon consideration of the notification dated May 6, 2005 and May 6, 2008, and subsequent notifications, if any, in accordance with law. No coercive steps shall be taken by the respondent authorities in terms of the show cause notices issued by them on October 31, 2018 and February 7, 2022, irrespectively, till a fortnight after disposal of the representation. Now, my lord, this matter was disposed of. Now, my lord, pursuant to this, my lord, a hearing was given by the Urban Development Department Principal Secretary, and a purported order, which according to them contains reason, was passed, which they are now subsequently quoting in their order. Page 46 is the forwarding letter. Page 47, the reason order starts. And my lord, page 48 is the observation. Last paragraph. In view of the above and on examination of the report of the Bidhannagar Municipal Corporation, Salt Lake, Reclamation and Development such and such submissions on the petitioners, it may be stated that the petitioners have changed the purpose of usage from automobile repairing shop stroke garage to other commercial purposes like opening shops and other commercial institutions without approval of the state government, in violation of clause 2(9) of the original lease deed. Moreover, Bidhannagar Municipal Corporation, being the building plan sanction authority in the report, has stated inter alia that various types of irregularities took place in the building and the land was pertaining to plot is completely violated. Land use pattern of the plot is completely violated. Therefore, the prayer of the petitioner to allow the change of purpose of usage of the aforesaid plot in question from automobile repairing shop to other commercial purposes like shops and other commercial activities and other prayers cannot be acceded to and is hereby rejected. Matter is just disposed of. Now, my lord, I wanted to give the money to the Urban Development Department according to the notifications 2005 and 2008. 2005, I have the notification if your lordship once can see. 2005 notification says that plot wise you have to give money and it will be regularized. And 2008 notification says that if you have been carrying on and government will give post facto regularization. Those were not done. And my lord, in violation of the order. Thereafter, this order was challenged in another writ petition, that is at page 49. I'm carrying the writ petition also if your lordship wants, my lord, to see what are the contents. Affidavit of service heard. Matters needs to be considered in affidavit. In affidavit of opposition.
An application in this writ petition.
My lord?
Why didn't you move
No,
an application?
previous writ petition was disposed of.
No, the current one, 25574.
Because this is a subsequent new, because this is subsequent cause of action, that is with regard to the.
This is after the passing of the order of the
Yes,
secretary.
challenging this order.
Challenging this order.
Yes, where I am fighting with the Urban Development Department. There, my lord, Bidhannagar Municipal Corporation is not a party. Because it is Urban Development orders which are being challenged, and the authority is Urban Development Department to regulate the conditions of the lease. Municipality is not. Municipality is supposed to, my lord, do its functions within the statute. Pending disposal of the writ petition, no coercive steps shall be taken by the respondents against the petitioners in respect of the plot in question, such and such. Thereafter, my lord, this particular notice has been issued. Now, my lord, may I just draw your lordship's kind attention to the subsequent enlistment certificates which has been issued by the Bidhannagar Municipal Corporation in respect of the same premises to the petitioners, which are, my lord, subsequent to, my lord, this filing.
Subsequent to passing of this order.
Subsequent to filing of the writ petition.
When was this order passed?
This order,
This Princess Secretary? The rejection of your conversion, page 48.
oh, rejection. Rejection is, yes, 19th October 2022.
This is the order which you have challenged in the
In
petition.
WPA 25574 of 2022. I'm having the copy of the, if your lordship wants. There, my lord, all the notifications, everything is annexed saying that this order, because government is supposed to regularize after taking money. I was willing to give the money, they said no. And the Midanagar municipality went and said that you are using it for any other purposes other than automobile.
Subsequently, you are saying that they have issued certificate of enlistment.
Yes, certificate of enlistment. I am having FSSI certificate. Now, my lord, one thing they have also quoted Section 304 of the West Bengal West Bengal Corporation Act 2006. Section 304 is eating license. 141 is trade license enlistment, which I have. Kindly see the dates also. This is 7 February 2023. The trade license that I have annexed with the writ petition are 40. Kindly see page 40. This was issued in lastly 27 January 2023. This is valid even as of today, 9 December 2029. And thereafter also they have issued trade licenses. This is also prior to that, my lord. This had missed.
Okay.
And my lord, these are the subsequent renewals also. Now, my lord, kindly, yes, there are many other trade licenses. Trade licenses and food safety under the FSSI Act. Now, my lord, kindly sees the language. This license, although in the nomenclature says Section 141 is the enlistment certificate, but the language I am saying, because this is similar to the Section 304, language used in Section 304. Trade license, callings of enterprise dealing with retail, sales, supply. Oh no, not this one, the previous. Yes. Eating house, restaurant, eating house come restaurant, fast food center. So everything. Eating house is there. Page 39 in also caravan cafe, eating house, stroke restaurant, eating house come restaurant. Now, Mala kindly sees the language of 304. Amar boite.
Yes.
This is Mala 304. 2006 Act. Rashid is having 2006.
2006, what?
Municipal Corporation Act 2006.
Not here. What is? Oh, it's there. Yes. What are you showing?
The language 304, because they have quoted 304. No person shall, without or otherwise than in conformity with the terms of the license granted by the commissioner in this section, or without payment of such fees as may be determined by the corporation, keep any eating house, tea shop, hotel.
No, but Mr. Larry, I think it is more to do with the fact that since your conversion has been rejected, they have issued this notice.
Yes, yes, yes.
That is what it
That is, and there is an order. You cannot act on the basis of the
No
there is an
question.
order, no coercive steps.
No coercive.
So that order matter I'll be praying.
Yes.
And other points are also there with regard to FSSI license and all these things, because as of today,
FSSI is not a is not relevant here.
Because 204 is there.
But why
304 FSSI is the central act having an overriding effect in section 89 of any other law.
That is not a
We have that
civic body. FSSI is not a civic body. He cannot override
statutory authority.
municipal statute. Anyway, my lord, that is not relevant. But kindly comes to, my lord, the order which my learned senior is banking on, page 49. My lord, admittedly, in the writ petition 25574, the corporation was not a party. They challenged an order of the department, UDMA. They came challenging and nothing had to be done with regard to the corporation. Your Lordship has seen, my lord, first two things are to be noticed in this order. Number one, the order of the UDMA is not stayed. So it operates in the field. Number one. Number two, last paragraph at page 49, pending disposal of the writ petition, no coercion shall be taken by the respondent.
Mr. Lyrie, you should have moved an application in that.
They
writ
did not,
petition.
my lord. Why? Because they moved this writ petition behind my back. The UDMA's order was passed upon my report.
The order on which you are relying,
Yes.
as far as no coercive action is concerned, that is an order which has been passed against the UDMA order,
Yes, yes.
right? You have not made them a party over there.
No, because
Any-
I don't have.
Any subsequent action which will be taken, you could have contemplated, it will be in terms of the Bidhannagar Municipal Corporation.
Yes.
You should have made them a party. They would have also been bound by this order.
And the UDMA order is based on my report. Kindly see page 48 bottom.
Yes. Now, my lord,
Yes, that I've seen.
they would have gone and said that this order doesn't restrict me.
It does not. This order will restrict them, no? Because till
I am
the-
not
till the
saying that.
time the issue regarding commercial change is there or not. The only reason why today they are in a position to take action against you is because of that rejection. If the rejection was not there, they could have not taken any action against you.
No, but there is one part. Another part is section 304.
304 is what?
304 is eating house license.
Eating house license, you have given it.
No,
to
that is under 141. I'll trade license. I'll show, my lord. What is the effect of the trade license? That will show.
Yes.
First of all, it is only under 141. It does not mention 304. And your lordship will have to see the bottom of the trade license. It is like self-assessment tax. Anyone can go to the website and get a fetch a license for himself. It is subject to physical verification. Kindly see the last box in each and every page. It is a self-generated document, my lord. Anyone will go put the trade, whatever bracket they fall under.
That is all right, Mr. Bandapande, but they have been running this business for a very long time.
Yes, no doubt about it. But there is
Today, what is the knee-jerk reaction for what?
But there is no, first of all, there is no eating house license.
Eating house license they didn't had from day one, right?
But
They have been
because, my
running
lord,
this place.
there is no action taken from day one. There cannot be any waiver of the statutory
I'm just
provision.
asking why this knee-jerk reaction? Any reason in particular?
My lord, because it has come to light that there is no other documents, etc., is also there. But once a person falls under scrutiny, they fall under scrutiny, my lord. But, my lord, because no steps have been taken previously, my lord, but it has to be seen, my lord.
Who's unhappy? Who didn't get the food?
My lord,
Or who didn't get the ice cream?
I do not know that. I do not know about that, my lord. But, my lord, since no steps have been taken previously, this step cannot be doubted with regard to that. It has to be seen whether the statute provides for the license or not, and whether they have complied with it or not. Number one. Number two is that order does not bind me. Number three, assuming I was a party to that also, the order is not under stay. Respondent, that is UDMA, is directed not to take any coercive step against them.
Yes.
And the finding, my lord, your lordship has already seen at page 48. Second last, third last paragraph, moreover. Or third last, the petitioners have changed the purpose of use from automobile repairing shop garage to other commercial.
You have applied for eating house license?
Well, I have been FSSI. FSSI, I have.
That is different thing.
No. And as of today, my instructions are, my lord, in Bidhannagar Municipal Corporation, they do not issue eating house licenses separately.
Are you issuing it? Separate licenses?
Because
Yes, it is required. It's a requirement of the statute.
There are a lot of times when there are a lot of requirements in the statute. You also know it, Mr. Bandapatiya. Are you issuing eating house license?
Whether this
Can you take instruction to that effect?
It is not issued. I don't have the instruction that the statute has been
Because
given.
they integrate everything in one license.
No, it cannot be, because kindly see the license, page 38.
License, I've seen it. It's 141 only.
It's only 141.
Yes.
How can 304 be read into it?
That's what I
Here,
want.
the language.
Because the word eating
Language.
house is a category. But if your lordship sees the two provisions,
Are the eating house in
absolutely
this area also getting 304 licenses or not?
But the
That is something.
purpose of the statutory provision has to be seen. If your lordship sees, kindly sees 141th language. language of 141.
Yes.
Malad has taken the book. Malad.
Yes, 141.
Yes. Every person engaged or intending to be engaged in any profession, trade or calling as specified in Schedule 2 as may be detailed in the guidelines issued by the state government for the purpose in any area within the jurisdiction of the corporation, either by himself or by an agent or representative, shall obtain government certificate of enlistment or provisional certificate of enlistment as the case may be, as per the modality specified in subsection 2, or for grant of permanent. So on so that is remaining is not important. So, my lord, any person engaged or intending to engage in any profession, trade or calling. It need not be a eating house. Anything, any trade, profession or business as mentioned in Schedule 2. Now, kindly take 304. It can be automobile parts also. Trade license is required. Then 304. Eating house not to be kept without license. So it's a bar on the person. No person shall without or otherwise than in conformity with the terms of a license granted by the commissioner in this behalf or without payment of such fees as may be determined by the corporation, keep any eating house, tea shop, hotel, boarding house, bakery, aerated water factory, ice factory or other place where food is sold or is prepared for the sale. Therefore, the language is contrastingly different. The purpose cannot be served by a nomenclature of 141. And 141 has to be read with Schedule 2 also, my lord, which also gives it in fine that in which cases trade license will be required. If it is non-profiting, then, my lord, no trade license will be required. But if you are earning profit, trade license will be required. That is qualified in Schedule 2. Such qualification is not there as far as 304 is concerned.
Yes.
There were 38, 39, 40. These licenses will not suffice for a license under 304.
Yes.
Number one. Number two, the writ petition which they have filed and kept pending for a long time, enjoying that no coercive orders, that is not binding upon me. And number three, the order which says that they are wrongly using the premises, that is not under stay, that is not under any stay. Therefore, it is operational, but the UDMA cannot take coercive stay against them. Other people can act upon that order. That is my understanding of the situation.
Yes.
So therefore, they say that yes, I can circumvent the order of the Honorable Court by one way or the other, knowing.
No, the problem is to that extent.
I am not circumventing.
This court is in agreement with Mr. Bandyopadhyay to the extent that if he was a party in WPA 25574,
yes,
then this order will be applicable on him also, no coercive action.
Yes.
But since you have not made him a party,
yes,
the coercive action is only to the extent of UDMA.
Yes, I bow down. But point is that.
And that is the reason the first reaction this court had, I asked you, why didn't you file an application in that, made him a party?
I could not have, because that is group 1 and this is group 5.
Ground
and any case,
11.
there is.
No, but it is all arising out of the same issue.
But this is, my lord,
If
they
you
have
wanted any
in that
protection-
case, in that case, they would have contended that look, the first paragraph is the same issue. Second paragraph 141, 304 is of not the same issue. That is with regard to implementation of the group 5 statutes. So that is why there is a new cause of action. I have come up before this lordship.
You go before them. This is just a show cause notice. Then why should
No,
I
my lord,
interfere?
no. This is not a show cause, my lord. They have
stoppage notice.
Stoppage.
This is a notice. Please treat it
Stoppage,
as the
stoppage.
West Bengal Municipal Corporation Act.
This is, you are therefore directed to close down. This is not a show cause, my lord.
You give them a hearing, Mr. Bandyopadhyay.
But decision has,
You have taken a decision
I'll
without
tell
even giving-
you.
Where was
Okay.
where was the show cause?
I'll tell you.
Let them file
After
the
my
report.
learned senior makes a submission that I do not have a license under 304. But there's the question of
Whatever it is.
developing or making up a case better than what is the
Bandyopadhyay,
situation.
Before you close down any eatery or anything, there's a livelihood involved in it. There are people who are working there. Where have you
It
given
is
them
an
a show cause notice?
Admitted case that
This
there
is
is
order passed under which section?
304.
304.
Does not-
304, it doesn't entitle.
It doesn't contemplate, it's a bar on them. It's a bar on them that without obtaining the license, I will not operate. The
You will not give
language
them
is
any
starkly different, Mullah.
All right, then I'll
And
stay.
it is, and their case is also, Mullah, kindly see ground 7 and ground 11. Ground 7 and ground 11. That is their ground.
You have to at least call for it.
But they have not pleaded the prejudice that without hearing me, some prejudice has been caused to me. And by going by my learned senior submission, is an admitted, what I have said in that order is an admitted case that they don't have a license under 304. It is their interpretation that page 38, 39, 40 suffices for a license under page section 304. That is the interpretation, that is a submission before this court. Today they cannot make up a case of
Mr. Larry, that will not, Mr. Larry, that will not hold any ground.
They have gone with that understanding.
Not 304. No coercive action as far as the order of the single judge is
No,
concerned.
I'm not praying similar orders as
No,
I'm not
similar
showing.
order. You are saying protection by that order. That
I'm
is what
saying
your writ petition says.
my
It
contention
says
is
that is in contravention of that order which has been passed by
Yes.
the learned single judge. They have.
I am in contempt of it.
They are in contempt of it. They are.
Well, that is the contention is that since UDMA rejection is one of the issues involved, since the UDMA rejection has
They are
been
not
well,
even
interfered
They
with,
are not even touching the UDMA.
then the first paragraph goes of this order.
That goes. Let
If
us
that's
assume
that paragraph
let us assume
goes,
that goes.
yes.
They are saying that you are not complying with 304.
With regard to 304, my argument would be that in FSSI Act 2006 Act, which has said overriding,
That will not have overriding effect on this.
but that is a specialized act,
Still, that will not have a overriding effect on this.
and it says that if there
FSI is a different legislation.
we have a central registration,
That
we
will
have
not-
all the
will not
licenses
have-
under
it will
that.
not have a
Only
overriding
when it operates in the same field.
It is operating.
It is not operating in the same field. That is food safety. This is
that will not
civic
have
amenity.
that will not have a overriding effect on this act.
It has to operate in the same field, same legislative domain.
Shall have an effect, notwithstanding
Mr.
it,
Larry, you take instruction on this.
as to whether they are issuing any other trade license or any other 304 licenses, that they can file a report.
If they file a report, I'm not saying it. If I'm not saying it, then they're taking action.
Because in any case, they have not taken action from 2023. So therefore,
that is also admitted case. They are flouting the order.
For them to take. I mean,
They are flouting the order. It's an admitted case.
I'll ask them to file a report.
yes, but in the meantime,
Then I'm not protecting you.
they will close before the pujas.
That's what I'm saying. That's the reason.
They will
I'm
close
saying.
before the puja. If your lordship remands this back, then also they will pass an order just before the vacation and close it before the pujas.
No, demand back, then so it's a long story. Long story. Then to you'll manage.
No. In this case, there is a why lordship it has fallen. Lordship, but my lord, fallen, my lord. In fact, what I'll say, my lord, the local council has come up with a complaint against me in this.
Please, no extraneous submissions.
That
please.
is there.
No extraneous submission. What they have done, what they have not done, what they have spoken to Mr. Lahiri about. Mr. Lahiri knows all the councillors there. He have all the information that is not pleaded in the petition.
See.
I don't stay there.
After this.
No, this is absolutely ridiculous submission.
After this, you see, I have records to that effect.
But giving any elbow room to these functionaries like this, but will give a go by to the statute itself. We will not be able to take steps against anyone.
Yes, Mr. Lahiri.
Yes, my lord. I'll be praying, my lord, short, my lord, interim order, and my lord, lordship, if kindly keeps it after vacation, and thereafter we'll fight it out. Because balance of convenience and inconvenience, my lord, as of today is
Balance
my
of convenience will stand on a prima facie case.
FSC case I have.
He is citing a writ petition where I am not a
So-called
party.
nothing.
His case is that I am in contempt of an order. I am not a party of.
All right, take down. The petition, the present writ petition is challenging the order dated 7/2/2023 passed by the Commissioner, Bidhannagar Municipal Corporation, whereby the petitioner was directed to close down all the commercial activities within commercial activities within commercial activities carried out from the premises number DC 27 27/26 or
26, 27/26.
27/26. Sector 1.
Sector 1.
Sector 1, Salt Lake, Kolkata. Ward number 40, Calcutta. Full stop. It is the case of the petitioner that the leasehold rights in respect of the plot in question had granted petitioner ऐसे कर लो. It is the case of the petitioner that the lease deed dated. What is the date of this lease deed?
20th January
20th January 1987.
1987. Yes, 20th January 1987.
20th January 1980 lease. It is the case of the petitioner that the petitioner, in terms of the lease deed dated 20th January 1987, was in terms of clause 2(9) was allowed to establish an automobile repairing shop, garage, as per the terms of the lease deed. Full stop. The lease also provided that any change in the usage of the plot of land would require prior approval from the government. Full stop. Subsequently,
notifications are not on record. If your lordship wants, I can give the notifications.
Subsequently, the petitioner who had made the application,
My father, predecessor,
the
original lessee.
the वहाँ जहाँ lease deed दिया है ना, lease deed in the name of late, what was father's name?
Manjulal Dev.
Manjulal Dev, father of the petitioner. Full stop. Father of the petitioner. Father of the petitioners.
Yes.
There are two petitioners. Father of the petitioners. Government. Full stop. During his lifetime, late, Manjudev applied for change of land use from industrial to commercial in accordance with the prevailing government policy. Full stop. In accordance with the prevailing government policy. However, no action was taken on the said application by the respondents. Full stop. Consequently, where's the first writ petition?
First writ petition, it is recorded in the
Consequently,
order dated, my lord,
Manjunath, through his nominated attorney, Mr. Somnath Ghosh, approached this honorable court by filing WP number 7659 of 2020.
17.
First is
1399. Kindly takes, my lord, page 41, 42.
13990 of 2017.
2017. Page 42. It's recorded in the first round of
Page 37.
37, yes. 37 is the order.
37.
37 is
full stop. By order dated 8/1/2019, read with 19/2/2018. This court disposed of the said writ petition with a direction to respond number 2 to consider and decide representation of late Manjudev Nath. Full stop. Pursuant thereto, the Joint Secretary UDMA, UDMA Department, conducted hearing in the matter, but no final order was passed. Full stop. In the meantime, the petitioners inducted tenants into the said premises, and such tenants obtained certificate of enlistment for carrying out their respective trades from the said property. Full stop. On 7/2/2022, the petitioner received a notice from the respondent alleging unauthorized use of the premises. The petitioner challenged the said notice in WPA number
7659.
7659 of 2022. By order dated 17/5/2022, this court disposed of the said writ petition, directing the respondent to consider and decide petitioner's representation. Petitioner's representation pending application for change of user on the subject premises. Full stop. In compliance of the said order, the respondent passed the order dated 19/10/2022, rejecting the petitioner's prayer for change of user. Full stop. Agreed thereby the petitioner preferred writ petition 25574 of 2022. This court-wide order dated 6/12/2022, directed the respondent to file their respective affidavits in opposition and in the meantime restrained them from taking any coercive step against the petitioner during the pendency of the writ petitions. Full stop. Learned counsel for the petitioner states that during the aforesaid interim order, the chairman the Commissioner Bidhannagar Municipal Corporation issued the impugned order dated 7/2/2023, directing the petitioner to desist from using the said premises for commercial purposes, failing which appropriate action would be initiated against them. Full stop. Learned counsel for the respondent, Bidhannagar Municipal Corporation, Mr. Sheshnay Bindopadhyay, states that the order dated 6/12/2022, passed in writ petition 25574 of 2022, is not binding upon them since they were not made a party before the writ court. Full stop. He states that the no coercive action is only for the respondent UDMA and is not applicable on Bidhannagar Municipal Corporation since they were not party respondent to the said writ petition. Full stop. He further states that the petitioners are carrying on the commercial activity in violation of Section 304 of the West Bengal Municipal Corporation Act 2006, since they do not have any license to run the eateries. Full stop. Though learned counsel for the petitioner states that they are having duly registered certificate of enlistment issued by the Bidhannagar Municipal Corporation, and the same is still
that was first one is till 2024. It has been renewed subsequently.
Issued by the Bidhannagar Municipal Corporation from time to time and valid till 2029.
The page 39 is 2029 and
2029, right? Valid till
one has expired and again issued.
And one of them is valid till 2029.
And 30, yes, 2029, both 2029.
2029. 9th of December 2029. Two of them is valid till 9th December 2029. He states that the corporation had issued the certificate of enlistment after duly complying with all the necessary formalities, and the same was initially issued in the year. First one, my lord, 2021, date of issuance, it is was
written.
Issued in the year 2021, and they have been since then carrying out the commercial activities without any hindrance or any show cause notice from the corporation. Full stop. They state that learned counsel for the petitioner, senior counsel for the petitioner, Mr. Lahiri, states that suddenly, without any show cause notice and without an opportunity of hearing, the respondent corporation has issued the impugned letter dated 7/2/2023, desisting the petitioners from carrying out their commercial activities in total contravention of the principles of natural justice, and that it is merely to harass the petitioner. Full stop. He claims that the said business has been running from the premises for the last so many years, and the corporation had not issued any show cause notice, neither initiated any proceedings against the petitioners. To burden the petitioner with a final order without even show causing or giving him an opportunity is in contravention of the principles of natural justice. Full stop. He further states that as far as the usage of the land is concerned, there is already a no coercive action order passed by the coordinate bench of this court in WPA number 2275 of 2022. Full stop. In view of the submissions made by the counsel for the parties, this court finds that the petitioner has not been granted an opportunity of hearing before passing of the impugn order. Full stop. There was no show cause notice issued to the petitioner. The petitioner has been running the restaurant for the last many years and have been duly issued the certificate of enlistment. Full stop. For a certificate of enlistment for running the trade business. Full stop. Trade eatery. Full stop. Learned counsel for the in view of such submission, this court prima facie finds that the impugned order dated 7/2/2023 shall remain stayed for a period of 8 weeks or until further orders, whichever is earlier. Learned counsel for the respondent seeks and is granted 4 weeks time to file his affidavit in opposition. Reply to the same, if any, within 2 weeks thereafter, list after vacation.
Deep localized. Deep localized. Deep localized.
Anything urgent?
Next item, item number 19. No.
Rest of the matters we'll have tomorrow.
Tomorrow.
I'm not feeling to.
Yes. Mal.
Number 21 of today's discussion, we are newly engaged from the legal end. I'll keep it after vacation. Item number 21.
Who's on the other side?
And
Friday.